when medical is taken in medical student, they made an application for migration because suffering from blood cancer. And the medical treatment only available at Kota. Both to more.
Here is a case where they have succeeded in honorable signature. Meet appeal is pending. And similar matter are already dismissed matter on the point of their in suppression of material fact, they got the job for which we are out. Let them forward. We taken up this one tender matter. My Lord, one tender matter. Tender matter of press admission. Give your slip.
Urgency that the permit to mention an urgency that because my termination was recommended since long, which was pending before the government. At that moment, I completed 90% work. Only 10% is when the work is gone. They have resigned without any hearing. This is the working season, my lord. I gave some
I may make a mention. Item 40 on your lordship's board. We have filed an interim application for amendment of the writ petition. The same has not come on board. We will see.
Main mention matter which is listed today is item number 30.
Item
number 30, which is specifically fixed at 2 o'clock. Very to request for surgery.
What is that matter about?
This is about the petitioner challenge the industrial policy wherein the petitioners, cement manufacturers have been exempted under SGST Act. That is.
So have you taken consent?
My lord, I'm appearing online for the petitioner. My lord, I believe the learned AG is to appear for the state and he is in some difficulty.
Yes.
My lord, your lordship had fixed it specifically for arguments today. May I request a short date? My lord, I believe your lordships are also working on Saturday, my lord, on 7.
This Saturday, unfortunately,
Yes,
I am not here.
Oh, then my lord,
That is the difficulty with me personally.
then my lord, is it possible to fix it on 12th, if possible, if it's convenient to...
It's possible. Can I ask learned AG once?
We will have a date, Mr. We'll give you a date.
Yes, my lord.
Please give us a date after consulting the Learned Advocate General and Mr. Gulati.
All right. Deeply obliged, my lord.
I will give apology that I should not make a mention, but from May, my lord, that is dismissed the writ appeal by the government in the lawsuit dictated, but I am waiting for my certificate.
No,
That has gone. That case.
No, my lord.
Appointment not approved.
No, my lord, it's not your lordship, my lord, Lordship Justice Ratha, my lord, that is Justice, Honorable Justice Raman and your lordship is sitting. That is Pune, my lord, that is the case your lordship said, no, I will be dismissing this. It will pass order. From May, my lord is not getting salary. That's why, my lord, I should not, but
no, you have rightly pointed that out. It was not there in my mind.
It's an abject penury. That's why, my lord, I should.
No issue. No issue. You can point that out.
In fact, you should. Sometimes we forget, so you should. That's why I thought the other one.
No,
other one we have.
That's not. That is the
We'll see, madam. Pardon your lordship. Fresh admission after your granting of lease. Lease, your lordship, in my favor, after being declared as the highest. Give us slippage.
Lordship, dismissal method, fresh admission.
Bail application on the year of 23, madam. That earlier bail was rejected by the Honorable Justice A.K. madam. Since I have given 2 to 3 memos in the regular court.
Regular court is, what can we do?
Regular court I have given memo, but it could not be registered, madam.
Is it a fresh matter or it has been adjusted to case diary?
Fresh matter, madam.
Formally it will come in the list.
That will be listed.
Chronologically it will be listed.
Chronologically already 2024
Oh.
Give yourself.
published.
Really.
Orders. Matters under the heading for orders. Item number 23.
Yeah, your lordship order dated 28th of August. Paragraph 3, your lordship may see. In paragraph 3, your lordship had permitted the petitioner to file a show cause reply, which she has done on the 20th of September 2024. I am seeking 3 months' time extension.
You are referring to which order?
22nd of August, the last order, madam, disposing of the petition, permitting the petitioner to withdraw. Lordship takes para 3 of that order.
Order number 7, Miller.
I've indicated the reasons, and in the meantime, he had issued opportunity of personal hearing. The right petitioner also has sought for time, 2 occasions.
You are for?
I'm for the respondent, opposite party.
So he has filed it within 4 weeks.
He has filed it. He has filed it on the 22nd of 20th of September.
Take a decision within 2 months.
Yes, I'm seeking another 3 months time for the reasons which I have stated in the application.
3 months.
3 months, because there are voluminous documents, much of which have been seized by the CBI. I'll have to.
CBI. That is because a CBI officer faced difficulty, so a CBI case was registered.
So, but 2 months time was granted, and you are seeking further 3 months.
Further 3 months, because in the meantime, we had issued notice of personal hearing to the petitioner after she had filed a show cause. But she has sought for more time to appeal.
She has sought for more time.
Yes.
Mr. Das?
Milord, unfortunately, Milord, I do not have up-to-date instructions on this matter, Milord.
Have you not got a copy of the IA?
Milord, I have received a copy of the IA, Milord. I had sent it to the client, but unfortunately, she is a little indisposed, hence has not reverted, Milord. That's what I was informed on the phone.
It is fixed to the 9th of December, next hearing. We have again issued notice to her.
She should ask for time.
Yeah.
It has to be personal hearing.
Personal hearing, we have, because show cause notice was given for termination. He has responded to that.
But you don't have any issue.
Milord, no objection, really. As your lordship pleases, Milord. As your lordship.
Your lordship may grant me time till end of February.
Yes. This application has been filed seeking extension of time for taking a decision on the petitioner's so-called reply pursuant to this court's order dated 22/8/2024. So, learned counsel for the file on behalf of so-and-so. Learned counsel for the petitioner has no objection to such prayer. This application is accordingly allowed. Stop time for taking a decision as was directed by this court by order dated 22/8/2024 is extended by 3 months from today.
Okay.
Yes.
Item number 24.
Grateful, my lord.
This
Grateful.
is already credible to respondent who have none. Notice is already sufficient respondent.
Yes. Served on 16th, so let us give one more chance. AD has been received after valid service of notice of the respondent, the IA elected. No counsel appears on behalf of the respondent, and hence this the case. 16/12/2024. Registry shall verify when any counsel is appeared on behalf of the respondent and indicate his her name in the counsel. Yes, sir.
Item 25.
25, my lord, notification of question of condemnation of delay. My diary was supposed to file it.
In course of the day, I will file the objection, your lordship, to the IA.
149 days.
My lord.
So what is your objection?
Objection, your lordship, the ground they have taken that not properly explained. Only they have stated due to official procedure.
That is not a valid ground. Is that not a valid ground?
But so long time.
In such type of cases, that is covering the case of Malayalam city, your lordship had
If condoning giving some cost,
No.
let us see your objection. Let us see if you've taken valid grounds in your objection. But you file it in the registry, all right?
My lord. I am forming the copy.
Yes. The condemnation of delay 149 days in filing the appeal. Where you see objection. The learned counsel for the respondent proposes to file today. Considering the facts of the case and after hearing the learned counsel, we consider this to be a fixed case for condemnation the delay in the excess of justice, but subject to payment of cost of rupees 2,000 to the respondent within 1 week, 2 weeks. Within 2 weeks. EIA is accordingly allowed. The delay in filing the writ appeal is condoned. The IA is accordingly allowed. Have you received a copy of the appeal memo?
No, yes.
I'll give.
Mr. Das, Karnataka victim, Mr. MC Mohanty. Mr. Bindisar Das, learned additional government advocate. The takes to serve a copy of the appeal memo. And Mr. Malayalam Media for Democracy, now within Thursday. Book connected matter. And by the after tomorrow, this is the case for fresh admission on 9th.
Yes, yes.
Possibly on, possibly,
Yes, yes.
18th of.
You'll get the date. All right, we'll check and give the date.
Item 26.
46, my lord. Pension matter, SLP is pending. SLP is pending and matter has been fixed on 10/12/2022.
Appearing for
Respondent 1.
respondent 1. Okay.
Dharan.
You are Mr. Sahu. You are Mr. Sahu.
SKNR.
So you don't hold power in this case.
No, on behalf of.
On behalf of Mr. Mahapatra.
Yes, sir.
SLP pending regarding what?
Similar matter.
To the state of Orissa versus who? This one?
Dharan.
No. This one. So the same matter is pending.
Same matter, similar.
This SLP involves Dharani Darjana or the decision on which Dharani Darjana is based?
My pardon, my lord. SLP Sudhanshu Shekhar Jana, my lord.
That is what I'm asking. Sudhanshu Shekhar we have posted to.
10th December. 10th all
Well, we have fixed to 10,
1037, my lord.
but they have not taken steps.
My lord,
That's the last order. We received instructions on 3011 as to the whereabouts of one respondent. Two others have died in the meanwhile. We have to file.
So you take steps, we are posting it to the same day as this
Yes, ma'am.
connected matters. In the meanwhile, you take steps.
a copy of the relative was supply.
Mr. Miss Aishwarya Das, learned additional and commits steps for service of notice on R267, steps for service of notice, oblique substitution of R6 and 7 shall be taken within a week.
2 weeks minutes.
No, we are making it the 1 week, try, because we are posting it to 10.
The department has tried looking for the address of the successors. They have not been able to find out.
Okay, wait. List the case on 10/12/2024 along with connected matters, WA number 614 of 2023 and back, as it is stated by Mr. P.K. Mahapatra, learned counsel for the respondent, that this matter is covered by the decision of this court in WA number 1134 of 2023, which has been challenged by the state of Orissa before the Supreme Court in SLP number 2146 of 2021. State of Orissa versus Sudhanshu Shekhar Jagan. Full stop. These Sudhanshu Shekhar Jagan and back. These matters have been heard on 19/11/2024. Full stop. We'll list the case on 10/12/2024 along with the connected matters. So you, Ms. Aishwarya Das Vakili, summons praise for some more time to take steps for for filing requisites, oblique substitution of respondent number 2, 6, and 7. She may do so in the meanwhile. Right? Not please. Okay.
27.
Here also, my lord, my learned friend appearing for the oversight is supposed to give a reply to the IE in condemnation of building.
The course of time, I will file the objection with it.
Along the back, as the connected matters with the IBO. So the WF for it. At 26. Yes, 27.
Sir, I appear for the objection. From the course of the, I will file the objection. No, you are here. 20 days, 22 days, we can control. 200 to file objection.
Mr. Sigo Prasad Swain, learned counsel appearing on behalf of the respondent, one or more.
One.
Respondent undertakes to file the objection to the confirmation of delay in course of the day after serving copy on Mr. Bimbisa. Please serve copy on him only.
Doctor, I will serve, I will file before the registry.
In course of the day, he serves a copy of the same on Mr. Bimbisa Das, learned additional government advocate in court. This case on 60. That's for the 10/12/2024. The objection shall be scanned and incorporated into the digital record.
From 28.
Delay was 576 days delay. Who is the contesting party? I'll take the notice to go.
No, you take the notice, but you had approached the Supreme Court, there you had withdrawn.
Yes.
File the review. And that is
It was in
actually-
fact filed on 4/9/23.
Sorry?
Lord, the review was filed on 4/9/2023.
No,
It is
that
late.
is all right. Writ appeal, where is the order in the writ appeal?
Lord, Annex of 12.
Here,
13, my lord. Is
Was there any
51
liberty granted by the Supreme
by
Court?
the Honorable Supreme Court to file the levy. That's why delay was required.
page is that order part of the SLP?
51 SLP, my lord, at page 53.
Page is- Notice. I, 421 of 2024. Since liberty has been granted to the petitioner to file the review, if you notice, file this review, if you notice, has been given to the petitioner by the Supreme Court in SLP number 22097 of 2023, if you notice to the, so there is one respondent or how many? Please check.
5 respondents. Including state, my lord, 5 respondents.
If you notice to the respondents on the question of limitation by register, there's only one, 4, 5 on the question of limitation. Notice on behalf of you accept for whom, madam?
Only 5.
Only 5.
Only 5.
Okay. Notice on behalf of respondent number 5, you accepted that is Suman Patnaik and an additional government advocate, an extra copy of the brief may be served on her. Extra copy of the petition of the IM may be served on her within 1 week. Full stop. Requisites for issue of notice on respondent 1 to 4 by registered post / speed post with AD shall be filed within 1 week. And returnable within 4 weeks. List the case on
6 weeks.
6 weeks. 20/01/2024. 25.
Orders were told. Item number 1.
There is only the five. There is only the five. The objection of the political party is correct.
May I please, my lord?
Yes, what is wrong with the order?
Pardon, my lord.
What is wrong with the order passed by the learned single judge?
My lord, I want to take your lordship to a last order, my lord.
What?
My lord wants to
No, let us show the legality in the order passed by the learned single judge.
Yes, my lord. That's why, my lord, please us to know my local stand, my lord. For which I want to assist this honorable court and take your lordships to annexure 3 of the writ petition. That is my intervention petition,
That we have seen.
my lord.
Even if we allow your intervention application, what is wrong? What is the infirmity in the order passed by the learned single judge?
Because, my lord, there is sufficient passage. The passage of the
That is not the
petitioner was
question. The fund was sanctioned
my lord,
for construction of what?
for construction of community center, my lord.
Where?
In the same place, my lord.
Which place?
The place where it was, the old building was
Where
existing.
that was existing.
No.
Now it is being constructed at some other place.
No, my lord. No, my lord. The same place, only 2 feet extended, which
That
is
cannot
not
be
disturbing,
permitted.
which is not disturbing, my lord.
No,
That
the
is the
order-
report, my lord. I want to.
There is no question of disturbance. The question is of allotment of fund for construction of a building at a particular place. So that the learned single judge directed that let the measurement be done by geotagging.
But geotag already done, my lord. Annexure 5, my lord.
All right. So they will do accordingly.
And my lord, only
No,
one
no
paragraph I
illegal-
want to assist, my lord.
Sorry.
No new construction has, the new construction has not affected the access of the using the same route. It is not
See,
disturbing, my lord.
these cases deserve to be dismissed with cost.
Because, my lord,
Unnecessary.
because my one last submission, may I proceed, my lord? The petitioner in the writ petition is the president of the village committee.
He may be president of the
That-
Odisha, but he will have to follow the law.
I am the intervener, my lord.
All right. Dismissed.
Court has directed that since it is being constructed unauthorizedly to demolish.
My lord, my lord.
Just for your benefit, it will be constructed again.
Item number 2.
In that case, in obedience of your lordship, last order, the director of the institute.
Let him come.
Yes, Miller. He has come in person. It is law.
Where is he?
Sir, he is that gentleman.
You are the principal.
Director,
Director, where is the NOC?
his NOC will not be.
Where is the NOC? No NOC means no objection certificate.
Yes.
Where is that?
Actually, he has not completed the form. That's why I have sent it to the university as soon as possible.
Whether you have issued NOC or not.
Already we have sent a letter.
Mister, we are repeating the same question. Whether you have sent the NOC or not. Say yes or no.
Yes, sir. Consent letter have sent.
Where is that?
Yes.
Unless you send the NOC in the proper format, can they act on it?
Sir, actually, format is not completed by the student. That's why.
So did you deny that NOC cannot be issued?
Not denied. Not denied.
You are harassing him.
No, sir. No.
We will initiate contempt proceeding against you.
Sorry.
A specific stand was taken that NOC has been issued. This was the specific stand taken on your behalf on the last day.
Mr. Das, on the last date, we were also asking you, where is the NOC? You pointed
Milord,
to a
NOC,
letter.
NOC in this sense, your lordship may kindly see.
The client depends on
One
you.
based on.
You are harassing a student
No, sir.
and you don't know the consequences.
Sorry.
By what time will you issue NOC?
Any one day?
Tomorrow.
Tomorrow is.
This matter tomorrow in compliance with this court's order. The director, which institute?
Copy number
The
4
institute is personally present in court. First off, he has assured this court that the institute shall be issuing a requisite NOC in course of the day. Stop, list this matter tomorrow. Stop. If in the meanwhile the NOC is not issued, the director shall be required to be personally present again.
May I, for the sake of clarification, may I praise just one thing, Milord? Whatever this form, Milord, which has been signed by the petitioner candidate, Milord, it was sent by the principal to the university, Milord. Now he has to give NOC in this Xerox copy, Milord.
Why did you say so? Instead of saying that NOC has been given.
Milord, that was my wrong notion on that day because of the
All right, forget, mend yourself. Please issue NOC by today. Tomorrow we will again take up.
Please give it.
Yes.
Right. Any document, anything, please do
He
it.
will appear there.
Yes, yes. If they want any on information, can
I
you
think
give
we
it?
appear at
Yes,
today.
yes, today.
Today.
Yes. Very good.
Your lordship may kindly take note of.
Tomorrow.
Item number 3.
Tomorrow you do whatever you want in the meanwhile, both of you.
You would have told us earlier, we would have done that. You said NOC has been issued. This is the problem.
I have
It's okay. No, you have insisted that NOC has been issued.
Item number 3.
I want to beg apology, Milord, for my non-appearance on last date, Milord. But here, Milord, my case is that
No, whether counter affidavit has been filed.
counter has been filed, Milord. Yes, Milord. Counter has been filed, and your lordship may kindly see the counter. They have relied on paragraph 4, page number 2, Milord, 8th line. But they relied that. May I read, Milord?
Yes, that you did not turn up.
Milord, page 2 of their counter, 8th line, Milord. After that, the petitioner was intimated by the office letter number so-and-so dated 4/9/2018 regarding deposit of royalty amount and to execute the lease agreement for operation of the carriage. Your lordship may kindly see page 34 of my writ petition, Milord. Page 34 and annexure 6 is that letter, Milord.
So whether the statement made in paragraph 4 is correct or not.
Milord, it is correct. Your lordship may kindly see page 34.
Yes.
Milord, in page 34, they have demanded but they have not specified what amount I have to deposit towards the royalty. They simply say, my lord, in the second paragraph, you are therefore requested to deposit the royalty amount and execute lease
So
agreement.
when was that issued?
My lord, that was issued on 4/9/2018.
4/9/2018.
Yes,
So did you tell them that you want to know the amount of royalty?
My lord, I have gone to their office. I have deposited rupees 1 lakh, which they admit, my lord, towards royalty. But thereafter also they have not given me the specified exact amount towards the royalty. Your lordship, may kindly see the timeline, my lord. On 17/8/2017, the advertisement for the signed queries were issued, my lord. On 22/9/2017, I have been intimated as a successful bidder.
See, the letter was issued on 4/9/2018.
Yes, my lord.
You did not turn up.
On 4/9/2018, my lord, I repeatedly requested them to specify the amount. Thereafter,
How did you request?
my staff went to their office and
Orally.
Sorry. Thereafter, your lordship may see, on 21/9/2019, the NGT cases were instituted. Then, my lord, I deposited 1 lakh towards royalty without any specific demand on 1/7/2019, which they have received, which they have admitted in their counter. Now,
Yes.
my lord, now my specific stand is that I am ready to deposit the entire amount.
Now it cannot be done.
My lord, at least they should tell me what exact amount should I deposit.
Exact amount in 2024.
No, my
The
lord,
demand was met in 2018.
my lord, thereafter the stay was continuing. Your lordship may kindly see.
All right.
They have, lordship may kindly see their counter, my lord. They have referred to it, my lord. On 16/10/2019, the operation, and 16/10/2019, the NGT issued the stay order directing no queries shall be operated. And
Yes.
thereafter, they refused to take any amount. The stay was discontinued by the Honorable Apex Court. Then after, I have made representation that I am ready to deposit, fix a date for executing the lease agreement.
No, not now.
Also, your lordship may see similar cases which I have pointed out in annexure. Annexure 12, my lord. They have also said that the case of the petitioner is different. But here, my lord, I stand in a better footing. I have deposited 1 lakh amount towards royalty, which they have not. And also, my lord, my query is also approved by the DEA. I am ready to deposit the entire amount. Their lease agreement has been executed, but mine is still pending, my lord. Now, since 2023, my lord, I have been giving representation to the authorities. Lordship will find the representation at page 75. Now, starting from 7/8/2023, I have been giving my representation to give me the amount for deposit of the royalty. They did not give.
Why have you given the annexure 12?
Annexure 12, my lord. Annexure 12 is an order where the similar bidders, my lord, who have not been executed, they made a representation as because the stay was continuing, but thereafter when the ethics court.
Annexure 80, sorry, page 83 is just an order to consider the representation.
Yes, my lord. After that, my lord, they have considered several bidders' representation on because of this order, my lord, they have considered which they have stated, my lord. But I have a copy. My lord,
Copy. Yes, it is. You have not stated, you should have given it along with this.
your lordship may
That
kindly
they are similar situated.
my lord, your lordship may kindly see, my lord. After that order of the collector and district magistrate Balisol. These are
So this is this there on record?
No, my lord, it is there. My lord, earlier they have stated that.
Is this there on record?
They have not given it on the.
Is this there on record, Mr. Counsel?
No.
Then why are you showing it? Is this a law?
No, my lord.
What is this then?
I just want to point it out, my lord.
This is the fact.
My lord.
So you should have stated in your petition. This is not the way that you will bring some document from your pocket and.
No, my lord. Earlier, my lord, they have stated on 4/11/2023 they have executed the agreements of some bidders due to this order at annexure 12, which I have given. My lord, in that order also.
Yes, is it correct that
One
there is
sentence
some clarity?
No, my lord. In the
You file an affidavit, we'll see. Have you filed any reply to the counter affidavit?
No, my lord.
You can file, you can bring that on record. Otherwise, you cannot do it. Like bring something, take out something from your pocket and say that this is the,
No, my lord, from the first.
this is not the way.
Considering the anxiety we have listed within first 5 cases.
I-
Last date when the counter was filed, you did not appear, so we thought you have no interest in the case.
No, my lord.
But we gave you one chance, even then you are not filing a rejoinder on giving the document on which you want to rely on.
Okay.
I am humble
Let's just
submission,
matter
my
on
lord. I am
4
ready.
weeks. So as to enable learned counsel for the petitioner to file a rejoinder to the counsel's affidavit filed on behalf of the opposite parties. Yes, 4 weeks.
Item number 4.
May I please, my lord? In terms of your lawsuit direction, Solicitor Board is here. He is here, madam. You will also may kindly see order dated 28/11. On that day, wrong submission was made before your lordship, that is why this order was passed. A wrong submission was made that instead of sub-collector, the Tahsildar has filed the affidavit. Your lordship didn't direct the sub-collector either or to the Tahsildar to file an affidavit. Your lordship directed me to take instruction only. But that was, a submission was made. The in spite of lordship direction, sub-collector has, Tahsildar has filed the affidavit. Now sub-collector has also filed an affidavit. Your lordship wanted to know from me, that is on dated, your lordship will find from 1911 order, 1911-2024. There your lordship directed me, if in the meanwhile this court's order dated 29/10/2024 is not complied with, sub-collector both shall be required to present physically before this court for this court to consider instead of contempt against him. Your lordship may kindly see 29/10.
29/10 order.
29/10 order is, the matter is taken up through hybrid mode. Lease this matter on 19/11/2024 within first 5 cases. Let learned additional government advocate seek instruction as to whether the petitioner's appeal, which is preferred in the light of this court's order dated 5/2021, passed in double petition number so and so, has been disposed of by the learned sub-collector, both or not. In the meanwhile, the defects, if any ordered way.
Then
Your
they
lord-
did 1911.
1911.
Yes, thereafter 1911. That's what I 1911. 1911.
Instructions came, that is why this order was passed.
No, that day a submission was made. 1911, by the time, yes, that is correct. Your lordship is correct. Thereafter, we filed affidavit. That was by the Tahsildar. That was a mistake. Subsequently, sub-collector has filed. Sub-collector was required to give me instruction or file affidavit. It has been filed on 30th of November.
So the mistake has been asked to appear.
I don't know. Can I say anything? My lord, 30/11. Your lordship wanted to know from me.
No, see, his, the direction for his personal appearance is not because the affidavit was not filed by a particular officer, but because you did not have any instruction as to whether the appeal has been disposed of or not.
Earlier order was not complied with. That is why your lordship directed.
So,
The affidavit did not contain any information regarding disposal of the appeal, which had been, you had been asked to get instructions on the first day.
It has been disposed of.
Yes, so indicate.
Disposed of.
It has been disposed of.
On who is there? When it is not disposed of in the affidavit.
yes,
If your lordship goes to that affidavit of 25/11, I have enclosed those documents. 25/11.
2911, it was not there. The 2910 affidavit, it was not there.
It was,
That is it.
it was not there. That's correct, ma'am.
therefore, where is the disposal of appeal?
Sorry, ma'am.
Where is the disposal of appeal?
That's what I am preaching. Now, your lordship may kindly see the affidavit I have filed on 25/11. There I have enclosed. 25/11.
Have you served a copy on him?
Right.
Who copy?
25/11
Tahsildar
2020.
affidavit.
There I have enclosed.
Well, I have a glass. In the
Mr. You please allow him to come. Yes.
25/11, the affidavit I have filed, I have served a copy on my learned friend.
It's there, man. What's it? Affidavit, notice.
Bookmarking, they don't know how to do bookmarking. Yes. No, they're saying affidavit issued. It is in reply to that.
Got it?
Yes, yes.
That is annexure A/2 and B/2, two documents I have given. Inviting reference to subject cited above, I am to return with the lower court case record as per order dated 19/8/2021, passed in RMA Lease case number so. Filed by Anil Kumar Mishra, son of Murupinjay Mishra, Bhutan, PhD, both in connection with Urdu Bilika Stone Query 6 for taking further action at your end. Appeal was heard at length, and after this, people were sent back to the conduct of further question action.
Where is that?
Again, where is the word disposal?
Disposal of body is not there. That is why I have.
Where is that? Where is that? You are reading
It
which
is not
case?
there. Your lordship is correct. It is not there.
Annexure?
It is not there. Disposal of body is not there.
A by 2.
A by 2. So he is referring the annexure A by 2.
Thereafter B by 2.
Has it been disposed of? I just returned.
Appeal was preferred by the. No, that is not there. I fairly concede the word was not there. Disposed of body is not there in the
No, no, this cannot be. See, appeal has to be decided on merit. Appeal cannot be decided on the basis of communication.
No.
So communication cannot amount to disposal of appeal. So what the order was passed by whom? Tahsildar.
No. It was asked by the sub-collector. Appeal was preferred before the sub-collector.
The original order was passed by Tahsildar. So the appeal would lie before whom?
Sub-collector.
Sub-collector.
It was filed before sub-collector.
So whether the sub-collector has disposed of the appeal.
That's what I am trying to persuade your lordship to do. That appeal was taken up in his presence. 3 bidders were there. Highest bidder having not submitted the certificate, his case was rejected. 2 bidders were there. The appellant quoted the lowest price. Higher price person, he was given that contract.
Where is that order? You have given something that record is written because it has no consequence on something. That is the.
So you are required to pass an order.
Sorry, sir.
You being an appellate authority were required to pass an order.
That order is there, but I got it subsequently. That's why it is not in the order that you have to do. Pura order.
Have you annexed that order?
No, they have stated that by the order dated 19.
Just a minute. Have you annexed that order?
No, that is I got it subsequently. That is why I couldn't locate it earlier. This file was not with me. This document has not been filed as an.
So give him a copy of the order.
Yes, if you want to permit it within 1 day.
Only refer on which date appeal was disposed of. Simple thing.
19/8/2000.
Kindly have a glance to the 19/8/21. I have annexed that order. 21, page 47 of my writ application. And it ends at page 48. Order ends at 48. 48 last. Case posted to 69/21 for hearing. How it is disposed?
Just one.
Yes.
He is correct over there. Thereafter, in that document, handwritten portion is there. It is not visible clearly. You are watching see the original one. Right hand column, handwritten, something has been written. It is not clearly visible.
LCR.
No, original. Can see. Original is written, my lord. Return the case record to Tahsildar to process for obtaining mining plan and clearance, etc. from competent authority, since it has not any.
See, we are giving you time. We are giving you further time to pass formal order of disposal of appeal.
And another thing, appeal notice to the respondents have not been issued. Without issuing any notice, disposal of the appeal will amount to non-compliance of the.
No, if the appeal is dismissed, then there is no requirement of issue.
If allowed.
If allowed, then we don't know.
If dismissed,
we don't know whether what will lead to.
Dismissed or,
sorry, the pursuant to this court's order, dated so and so, the sub-collector Both is personally present in court. First off, after having seen the counter affidavit filed on behalf of the opposite parties and considered the submissions advanced at the bar, whereof the review that the order passed by the sub-collector dated
19/8/21.
19/8/2024,
21.
21 does not amount to formal disposal of the petitioner's appeal which was pending. So stop. List this matter on 2 weeks within first 5 cases. Stop. The court will, first 5 cases, the collector both, sub-collector both shall be required to pass appropriate orders in the said appeal, in the meanwhile.
Offering opportunity of hearing, because the case was posted for hearing. Hearing was not done. This is the.
So stop. And counsel for the petitioner assures that the petitioner shall appear before collector both, sub-collector both on today's 2nd, on 6th. 6th you appear before him. What time?
On next week, there are
On 9th.
on 10th.
On 10th.
10th.
On 10th.
He will bring back the record because record is not with him, the lower court record.
All right, he will do whatever he is.
Yes, because he has transmitted the lower court record to the binding officer.
You are an appellate authority. You should have been careful.
Yes. Already all
This
the
is not the
records
way
have
the
been
appeals
transported
are-
to the binding officer. And it's a B to clear that.
17th. It will come on 17th.
My lord, I'll
No, he will not be there.
Keep on.
Yes,
My lord, I'll
dispensed
ask the officer to remain present.
Dispensed with, I have dispensed with.
Item number 5.
Learned friend, appearing to the state may take instructions from opposite party number 2 on the fate of my application. Under annexure 1,
Just.
Directed me to inform this honorable court regarding any decision taken on the aforesaid representation.
Yes.
My lord, despite 2 communication, my lord, I am not receiving any response from the OP number 1 and 2. Only I am in receipt of one communication from the OP number 3, who is the deputy director mines. He states that, my lord, the matter falls within the Koira circle and not under the Raurkela circle. Therefore, the wrong party has been added. So, he is unable to brief me regarding this matter.
it is the opposite party number 2 whom an application has been
At
made.
least one opposite party number 3 has wrongly been mentioned.
That's a different circle, but the decision has to be
That we
taken by
understand.
opposite party
We
number 2.
understand.
But
Oh,
even internally, they have to obtain instruction from that mining officer. If
No,
it is
this
the
is not instructions from the mining officer or the deputy director. The instruction is, well, basically on the policy.
You do that also.
I'll do that. I'll do that in course of the day. I will have that corrected in course of the day. That instead of Raurkela circle, I will just make a circle, Koira circle.
Only 7 days time maybe.
No, we are directing for personal appearance of the director.
My lord.
Or he can join the proceeding at 2. This is not the way. See, he is not listening to you. You are their counsel.
I have specifically.
And they are not responding to your communications. Then they will respond to our orders.
I will go and call the director and inform him.
Call the director,
At 2
and at 2 p.m. we will take up the matter again. This cannot be taken up so lightly that they are not responding to the law officers.
Tomorrow, at least, your lordship.
All right, 2 p.m.
Please check if your letters have been sent.
Yes,
or
yes,
not.
letters I have checked it. I have checked it. My letter has reached them pursuant to my letter that response has from my lord. That is at 27th, my letter, and 28th also I have completed.
If he has any problem in sending the responses to you, you please ask him to be here at 2 p.m. He may join online.
Tomorrow at 2 p.m.
No.
Today.
2 p.m. Inform us.
Admission item number 6.
I'm permitted to withdraw item 6.
Withdraw.
Item number 7.
On the file is.
The cost are paid on 30/11, but receipt rate file it, so it has not come later. In course of day, I will file this and this.
Check
That's
the
cost.
cost, check the cost and fine. All right. So what is this matter? Why are you withdrawing?
My lord,
What is this matter? Challenging.
matter regarding promotion of an OSF of junior branch team. When vigilance case is pending, that's why promotion.
That's all right. Withdrawing. That means you will comply with the order.
Item 6 is.
It's appeal, you are
Item
withdrawing.
7 is 6.
Item 6.
Item
6. 6 total.
6 I am withdrawing, madam.
Item 7.
Please file a memo.
Yes, ma'am. Where this during the question is whether during pendency of the vigilance case, promotion can be given or not, the only point here. And discipline proceeding was also there, discipline proceeding has been squashed. So Lawrence singly has directed that his promotion case be considered. That is what we have.
Yes. Yes, next.
Item 7.
No, 7.
Item 7.
7. Item 7, from junior branch 1 to Gunner to senior branch 1 OS officer, chief for promotion. Vigilance case is pending against him. Discipline procedure was that was squashed. But the Lawrence Singhal just said that pending this vigilance case, he may be considered, his case will be considered for promotion. That is what we have challenged that during vigilance proceeding, unless there is complaint, he cannot promote.
So this is what we have also held in one of the cases.
I may be allowed some time to file my objection.
All right. No, he walks away. But notices were issued, you have appeared. It's 2023 matter.
No, the last day I have appeared and the delay was called.
All right. London Council appearing on behalf of the appellant seeks short adjournment. Respondent seeks short adjournment to address this court. So he has entered appearance recently on behalf of the respondent. As requested, list this matter on 2 weeks.
3 weeks.
2 weeks, you sought 1 week. All right, 3 weeks. All right.
Item number 8.
May I please your lordship, in this case, I seek one adjournment to take instruction, madam.
Instructions, you are appellant.
Yes, madam.
Then what instruction?
1 week time.
What instruction will you?
Because whether the appellant is observed regularly or not. Yes.
Observed regularly. Let us see the order. No, Mr. Sorry. This is not an order at all.
My lord.
Just come to paragraph 5 of the order.
Yes, my lord. In this case, what happened, my lord?
How can you challenge that order?
My lord, because the petitioner in the single just before was claiming for the regulation for the course of Group D employee. But on the date passing on 21st/3/2023, simply the opposite way stated that is the observed.
Please come to paragraph 4.
Yes, ma'am.
Please come to paragraph 4.
Yes, my lord. The petitioner in the meantime has been re-engaged in the accordance with the temporary status.
Then
No, my lord, I am already regularized which is challenge before the single court, single.
regularized.
Yes, my lord. That is at nature.
Then why did you file the writ petition?
That has been cancelled the and just kindly come to page 24, my lord. Annexure.
Page
24, annexure 3 to the writ petition, my lord. That is order dated 4/2/2015, my lord.
Yeah.
The common list of 105% were confirmed with the temporary status of GA Department Office Order and so and so that here we observed against the existing vacant post of Group D employees, man.
Yes.
My name is at serial number 15, man.
Yes.
Accordingly, I joined and started my work, man.
Yes.
And against the Group D post.
Yes.
What happened, my lord? Page 20. Sorry.
27.
Yes, ma'am. Page 27, sir. My observation has been cancelled, ma'am. That is the challenge.
It is cancelled because you said there was an error. You belong to SCBC category. Name has been included in the unreserved category.
Exactly, my lord. The other person was continuing as a SCBC category was observing that list, my lord. That's why I filed the case, my lord. So, my lord, kindly come to page, again come down to page 22, my lord. My name is serial number 49. One person, another person was page 23, whose serial number is 76, my lord.
File your affidavit. He has some case.
Let's, can I refer to our counter affidavit which was filed at page number 29?
One said that
That portion is answered in the counter affidavit.
page
29, 28 is our counter affidavit.
What is there?
Counter affidavit on behalf of respondent number 1 and 2, annexure page 28.
In reply to the 29, kindly turn to next page 29.
No, but see, he should have been given an opportunity. Simple. And he could have explained. You might have rejected.
Let us take instructions.
That is, yes. So notice. Now, we make it clear that the only point which the court in the present inter-court appeal shall consider as to whether any notice was required to be, so-called notice was required to be issued to, whether the respondents were required to give the petitioner and appellant an opportunity to so-called /hearing if they intended to recall their decision to absorb the petitioner against a Group D post, by subsequent order dated 12/3/2015, which was under challenge before the learned single judge.
Not for 2 years thereafter you have.
Like only case which we have made.
That is the only thing. And he could have seen what he is submitting before this court here or before that could have been done before you. You could have explained that or whatever. But that right will have to be respected.
My lord, the only point which we have mentioned is that because inadvertently it was mentioned in the general.
Maybe inadvertent. So you could have given him that these are mistake. We are going to take away. You had given him something, and thereafter you are taking that back. So there, before that, you will have to give him an opportunity. That's all.
So if you look at it, the impugn order, there is a mistake because he is in that temporary status since long, not recently, not in 2016.
We will see. 2 weeks. 4 weeks. 4 weeks.
Item 9.
Why please?
Sixth.
Yes.
There was a recruitment to the post of homeopathic medical officer that the advertisement made was in 2015 and 16. And according to the advertisement,
What is wrong in the order?
followed that prayer in the tribunal, that is the original application was twofold. That I have made a prayer in the tribunal that the direction may be given to the Odisha Public Service Commission to take up immediate step for re-evaluation of the answer sheet giving 1 mark.
But Mr. The only
Yes,
ground.
twofold. Yes, I am pressing. Twofold. I am pressing the first prayer. Second prayer was not pressed before the tribunal because I do not want to disturb the select list. Yes.
See, the decision will not depend on your wish. The decision of the court will not depend on what you desire.
No.
So if relief was to be granted to you, then the whole selection process, whole selection list was required to be disturbed.
I do not want to disturb.
You want your desire will not do, Mr.
Just I am placing. There are 263 posts are vacant. Only 169 candidates were selected. There are 94 vacancies are still there. That's why court that tribunal has directed that 1 post should be kept vacant. And I have not want to disturb the second merit list. That what
Again,
happened?
you are saying you don't want to.
That what has happened in the merit, that one question number 25, that the petitioner has given the correct answer, but the key answer supplied by the OPSC was wrong. That's why 1 mark was not given.
So the person who was selected, we don't know what answer he had given against question number 25.
No,
he had a right to be heard. And he had, like he would have told that, see, what you are saying is incorrect and what they had done was correct.
I am pressing it because of the textbook. I have given the textbook. Lordship may see the 7.3.
We cannot read here.
Yes, that is true.
Deciding writ matters. Yes.
That is true. That let them evaluate that basing on the textbook. Textbook has given that the correct answer is that answer number C to the question number 5.
The counsel, we cannot convince you.
Yes. In counter, they have stated that we have no process to evaluate it. But according
They
to
have no process to evaluate.
yes, there is no provision in the counter. They have stated that Lordship may see their counter.
Mr. Counsel, your defect has rightly been pointed out by the learned single judge, and your
that I have not made parties to the yes. That is
because
correct.
you did not want therefore.
Yes, I do not want seniority among them.
Seniority.
Anybody may be given because the person who has secured a less mark than me, they are being selected. But I do not want seniority among them because there are several posts.
See, you are kind enough to them that you don't want you want to lose your seniority despite the fact that you are more meritorious. But law is law, we have to follow.
Yes, in a similar case also.
Just 1 minute.
They were already selected. The persons were already selected.
A person, 169 persons are selected.
Selected, so they have the right to be imputed. We'll see, so notice. You are for?
For the Odisha Public Service Commission.
All right.
But I may just clarify with regard to the
State.
number of vacancies. There were 131 unreserved vacancies. All 131 have been filled. Total is the 263 vacancies. There are vacancies in ST category posts. That is my specific stand in the counter affidavit.
Lordship may see the select list. 131 unreserved posts are vacant, out of which only 26 male candidates were selected. Female candidate 55. There are several posts in the unreserved categories are also vacant.
I can demonstrate from the, if your lordship has
In
the-
their selected, that is the annexer, Lordship may see the annexer. Annexer 11.
No, whether affidavit was filed in that case or not. In the writ petition.
Yes, ma'am. Counter affidavit has been filed. Our specific stand is that 131 UR candidates have been selected. I can demonstrate that from Annexure 11 as well.
Have you filed any rejoinder? Have you filed any rejoinder?
Yes, I have filed my rejoinder. Yes, I have filed rejoinder.
This is what they are saying, that 131 once your candidates were selected.
An unreserved candidate, that is SCBC and also SC candidates are also included in 131.
That they could not have done, no?
Yes, yes, in their counter.
All
Lordship may see the select list.
Sorry, sir. Dismissed.
Item number 10.
It is request of the respondent, we couldn't go to file the affidavit, so we need 2 weeks time.
What?
2 weeks after.
What?
We want to file affidavit in the writ appeal. The point they have not taken in the counter, they have taken a new stand in writ appeal. So we have to, by way of pleading, to bring it in affidavit. Due to sickness of the respondent, we couldn't file it in time.
Why will you file an affidavit?
Some points in the counter have been, they have.
That you can demonstrate.
I need time, my lord.
What? Time is different, but not for filing affidavit.
Last occasion, your lordship had.
Last occasion we had given time.
Yes, for filing.
Therefore, we are bound to give you time again.
No, that. We need one on that time, my lord.
And you have already filed objection. What else?
Objection in the limitation. Limitation delay I have already condoned.
I have requested on behalf of the applicant, list this matter on. Respondent, list this matter on 1 week. Let him prepare. But no affidavit. We will record that you will not file any affidavit. Should we record that?
1 week.
Don't file any affidavit.
1 week to get prepared.
Yeah.
Not that.
1 week after.
10, 12.
Item 11.
Babe, I'm sorry, man. The last occasion I had some personal difficulty, but my lord, I was absent from the court. This case, my lord, an appeal was filed by the respondent number 5 in the tribunal, the State Education Tribunal, under Section 10A of the Odisha Education Act 1969, for a prayer which is not available to be agitated in an appeal, because State Education Tribunal has power under 2 counts, my lord. If somebody is terminated, only appeal lies under Section 10A of the Act. And can you see, man? And Rule 27, 1974 recruitment rule also, there is another provision, appeal can be filed against the termination if the procedure has been violated on 2250. Just kindly see the provisions of that will be at page 144 of that book. Of the book, condition of service of the aided institution. Page 145. 10 capital A. Service of the teacher of the aided institution not to be terminated without approval. The service of a teacher and other members of the staff of an aided educational institution shall not be terminated without obtaining the prior approval in writing of the director. In the case of teachers and the members of the staff of a college, circle inspector of school having jurisdiction in the case of a teacher and other members of the staff of a school or a school, every order passed by the director or circle inspector of school, as the case may be, either according approval or refusing to accord approval under subsection 1, shall be communicated to the parties concerned within 3 months from the reference. Then 3 is important. Any person aggrieved by an order passed under subsection 1 may prefer an appeal to the tribunal within 1 month from the date of receipt of the order. This is the first provision. Against the termination, under this provision, my lord, appeal can be filed before the tribunal. Employee. Number the second provision I want to say under the statute, that is under the recruitment rule 1974. My lord, kindly have a glance. That rule starts with page 976 of that book. And 976, the Odisha Education, Recruitment and Conditions of Service of Aided Educational Staff, Rules 1974. 976, man.
Yes.
My lord. Kindly turn to Rule 22, the procedure. Procedure for imposing measure penalty, 996.
Yes.
Now, my lord, kindly turn to Rule 15. Sub-Rule 15, sorry. The employees concerned may within 30 days receipt of the order under Sub-Rule 14 appeal to the tribunal setting for the ground of appeal, so and so, so and so. 14 is decision with regard to commission appeal concerned or the imposing penalty. If a penalty is imposed in a proceeding, maybe a termination or any other penalty as provided under Rule 20. Rule 20 provides the penalties. So he can also file an appeal to the tribunal. These are the only provision for filing appeal. And the other criteria before the tribunal is section 24B. The other category of cases can be filed. Well, kindly have a glance to section 24B of the Act.
Yes.
Well, that is at 159 page.
Yes.
Adjudication by the tribunal. The tribunal shall have jurisdiction, power, and authority to adjudicate all dispute and differences between the managing committee or the education may be the governing body of any private educational institution and any teacher, employees of such institution or the state government or the officers or authorities of the said government relative.
So there are two kinds of
cases can be filed before the tribunal.
Yes.
If it is a dispute with regard to payment, non-payment of granted aid, a GI case is to nomenclature is GI granted aid case. And if it is a termination, my lord, only appeal.
Yes.
So now, my lord, kindly see what was the prayer in the appeal. Yes, fine. The appeal number 6.
Yes.
My lord, the appeal is at
Just, I'm sorry.
page 20. Yes.
Did you refer to just now?
What
ये जो education quota है
74 rule.
नहीं नहीं ये जो education act में जो
Oh, 24B, you know, granted aid case. Where, my lord, if a dispute with regard to payment, non-payment of granted aid of an employee, GI case is to tribunal.
application before the tribunal.
Tribunal.
So you are saying
ମୁଁ ସେଇଆ କହୁଛି that
appeal ହବନି ये
ହେଟା granted aid case ହବ ଦିଟା nomenclature first termination ହେଲା appeal 10A ଯଦି problem ହେଲା with regard to payment granted aid then that will be nomenclature GIA case.
So is
They two different judgment of
both are maintainable before the tribunal.
but two different type of cases, man. All are maintainable for the tribunal. These two type of cases are maintainable, but the nomenclature is different. And that our own High Court judgment in 2008 Justice Piketty Party division में judgment.
So what was the dispute before the tribunal?
Yes, my lord. Just I am holding the appeal. So kindly see, my lord. This is an appeal, page 50, annexure 4, 50. This was an education appeal filed in the tribunal.
Yes, page?
Page 50, annexure 4.
Page 50.
My lord.
Writ appeal.
Appeal. That is the appeal petition filed by the appeal number 5.
No, of the 50 of writ appeal.
Yes, madam. Yes.
Annexure 4 starts from 135.
So are you referring?
No, sorry, madam. In the tribunal, it is page 50, my kindly see, madam.
Page 50.
Yes, only 50. Single version. That was part of the writ petition.
Just a minute. Yes, sir.
December.
Yes.
Mine. Kindly see this is an appeal. First heading is education appeal number 24 of 2011. This is an appeal was filed. So therefore, necessary inference should be that should be a termination. Otherwise, the appeal could not lie. So kindly see the prayer at page 55 in that appeal. Part of the prayer.
Yes.
It is therefore prayed that the Honorable Court may be graciously pleased to admit the application, call for the records and issue notice to the OPs and appointment letter of the OP number 7. I was the OP number 7 there. By Annexure 9 series, we quashed the appointment details table by Annexure 7 and 8 to correct, showing the petitioners a senior appointee to OP number 7 and the opposite parties be directed to give the post of head clerk to the petitioner with the consequential service benefit and may further be pleased to pass any other orders direction as deemed fit and proper and to the effect of kindness. This was the petition filed. And
Let us see the functions of the tribunal.
Mine.
Where is that? See, 10A is something else.
10A is the power conferred under the tribunal to hear an appeal of an added institution employee against the order of appeal. The power is there. Section 10A3. Any person, shall I read 1 second, madam? (24A) is the constitution of the tribunal is there, madam. 24.
Now, what are the functions?
Yes, madam. Kindly see. This 10A was introduced by way of an amendment in the year 2010. Kindly see. Constitution of the tribunal. State government may.
So this is your this is your case that the application or appeal, whatever was filed before the tribunal, could not have been entertained because the tribunal did not have the jurisdiction to entertain the dispute.
No,
this is your submission.
No, I would yes, madam, one part of the submission. I have to clarify here. First of all, the tribunal have the power to decide two type of cases. If this dispute is with regard to seniority, grantinate, head clerk posting, approval, everything, that is only maintainable under GIP or by filing a grantinate case, not an appeal, because there is no question of termination. So appeal is not maintainable. It should have been a GI case. It is the first matter. Second is, madam, the judgment of our own High Court is the cancellation of an appointment of an employee cannot be challenged by another employee or any other person before the tribunal. That is on 24B also, that application is not maintainable. This is the division bench judgment of our High Court.
So whether that division bench judgment has been considered by the learned single judge?
No.
Did you rely on that?
Yes, I from that is my case, madam. I then have not been stated here, but I have filed it.
Now, have you taken this ground?
And my lord, kindly see, therefore, at the first instance, page 180 may kindly see. Page 180. Yes, madam, kindly see judgment. That therefore, at different bench, page 180 may kindly see. Honorable single judge, at one point of time, asked an order to hear it on maintainability. Because this is a point of law. Kindly see page 180, thereafter this judgment.
Yes.
Well, page 180, Annex 7C, I have given. Page 180. This matter taken up for High Court. This is order dated 5/4/23. Release this matter on 19 April. The parties will
Why
address
are
the
you relying
court
on
on the
this?
My lord,
Why are you relying on this? Yes, paragraph 9.
court, my lord, the judgment. Oh,
Yes.
sorry. Just a minute. My lord. My lord, paragraph.
You said justice Tripathi?
সেটা হচ্ছে অপিল সেটা আউট হয়ে সেটা অপিল হবনি এটা হচ্ছে উইথ রিগার্ড টু দি মেইনটেনেবিলিটি অফ দি কেস বিকজ হি ইজ কোশ্চেনিং মাই অ্যাপয়েন্টমেন্ট দ্যাট ইজ নট টু বি ডিসাইডেড বাই দি ট্রাইব্যুনাল opposite parties have I am reading out paragraph 9 man of that judgment. The opposite parties have also taken objection that the order of termination.
Have you seen this decision? Please consider this decision and address. Run counsel on behalf of the appellant relies on relies on a division bench decision of this court in case of Gokilman Panda versus State of Odisha and others, reported in 2000 volume 2 OLR 2010 to submit that 210 to submit that a dispute relating to appointment or cancellation of appointment does not come within the jurisdiction of the Odisha Education Tribunal in view of the amended reasons of section 24 capital B bracketed 1 of the Odisha Education Act. Full stop. He has submitted that the learned tribunal wrongly entertained the claim of respondent number 7. Claim of respondent number 7 pertaining to cancellation of his appointment.
My appointment. He was
cancellation of seeking cancellation of your appointment. Seeking cancellation of
seniority of both petitioners was in question. And tribunal held that appellant was not validly appointed because there is no proper advertisement.
We will see. Just go through the decision. This is what is list this matter on 1B so as to enable and GA to consider the said decision. We can issue notices have been issued.
No notices. Private petition.
Yes, and the paragraph 9 specifically refers to 24B1.
Yes, that is the only power jurisdiction.
No, that's okay.
Issue notice. Issue notice. Yes.
Now the steps are being taken to at least status quo as in today.
No.
Or no, because if the other person will be approved, then I will be the one post. Where both are quarreling each other. Well, I don't kindly have a glance. Only some protection.
Not now.
Some protection.
Not now.
All notice on that I
am very miser.
Pilot is good. We have seen. We are every day.
Yes.
In cases, if I have a case, pilot is right.
Item number 12.
Yes, Mr. Ranjit Kumar, you are here in which case?
12 o'clock at Object said I got 34.
All right. We will take it.
Item 12.
Yes, sir.
Case proceeding has been initiated. Irregularities in the and I have prepared a soft note, on the critic note, 2-page note. I have prepared all the submissions I have made. Annex 11, the enclosed, and I have enclosed the submission also. Nothing has been considered. There is complete violation of natural justice. Lots of time to come to this short note I have given.
So where is the order?
Input order Annex 12. 5 points I have agitated, the investigation report, the statement of the witnesses taken in the investigation report, those are the delinquents. They have been examined in the regular inquiry behind my back. and punishments are inflicted. And the finding of the inquiry officer is not proved. Case 76, if your lordship kindly come to this conclusion part.
That cannot be.
Yes.
There's 76 your lordship. From the perusal of the management exhibit, defense exhibit, analysis of the depositions made by the witness and submission made by the PO and development findings in respect of various artificial charges. Defense appointed is the CSO himself. He did not submit DR even after remanded to him with available investigation report. PO brief regular inquiry, it is concluded that EK Patel has not handled the account judiciously while enhancing the limit, obtaining execution of the loan document, allowing ad hoc limit. The charge of diversion fund is not fully proved by the PO. This is the findings. Your lordship kindly, I will be grateful. Your lordship kindly come to points I have made. Short note I have prepared.
So is it your case that the witnesses were examined in your absence? Is this your case?
Witnesses were examined in witness has been examined. My lord, what has happened? The investigation report made the statement on the basis of which the investigation has been conducted. They are the delinquents in separate charges. 4 delinquents are there and against the irregularity. 2 are managers and 2 are the senior manager and this officer. So 2 dates the inquiry has been completed. Investigation report 3 with 3
What is investigation report?
Investigation answer 3 I have enclosed.
Investigation or inquiry report?
Investigation.
Investigation before inquiry.
Before inquiry.
Before inquiry, some preliminary inquiry was conducted.
Conducted.
So has the inquiring authority relied on the investigation report?
Sir.
Whether that investigation report was given to you?
No.
That investigation report was not given to you.
No.
And the investigation report has been relied upon by them. Are you sure about your submission?
Yes, madam. That I have made. That I have made. All the submissions I have made. Annexure 11 also that complete submission I have made before the writ court is a single way. And nothing has been taken cognizance and order has been passed. And my
Yes, is it correct?
Proceed.
Just let us understand this.
On the basis of some allegations that some irregularity has been committed in certain account, the disciplinary authority directed deputed one senior officer to investigate. He investigated the matter and found in relation to one account that account went into NPA on 30th March 2013. Thereafter, on 24th April.
We are not concerned about that.
Yes, ma'am.
Some investigation was conducted.
Investigation report was submitted to the disciplinary authority. Disciplinary authority sent a copy of that investigation report to the delinquent officer.
Oh, this is what he is disputing.
Yes, madam. That I have already produced the entire departmental proceeding file. That is all for us in court. We have not taken it back. I will just show from
when
there.
was that submitted? When was the original reports? You say?
Yes, madam. At the time of hearing, because not a single judge.
Let us give the direction before they have such.
That has not been returned.
Not only the recovery.
This time. It's there. All right, we will take up the matter next week because we all. This is what he has 2 submissions, as we have understood. One, that you have relied on the investigation report, which was not supplied to him, and 2, the witnesses were examined in his absence. These are only 2 grounds.
Both the submissions have not.
And 2 dates, my lord, 2 dates, my lord, inquiry has been.
That can happen in one day.
My lord, the case is like this.
That will
Irregularities in the 4 delinquents are there. 2 officers, they have been
they have been censured and 2 have been,
No, my lord.
the major penalty have been imposed.
What is the major penalty?
Major penalty, my lord, downgrading 2 stages, 2 increment cumulative.
Other 2 officers are supervisory grade officer and they have been awarded a higher punishment than the delinquent.
And rule provides a common proceeding should be there.
All right.
Their proceedings, I have enclosed the rules.
That is not mandatory.
And my lord, the appeal also disposed of they have not disposed of in speaking order.
Yes, we'll see.
2743 of 2024 along with item number 14.
Is this case?
Writ appeal number.
Along with WA number.
Obliged.
14. 1-4. 14. One matter. One first matter.
Give the number.
Yes. 2743 of 2024. Monday. Item number 34. Sir. Yes, Mr. Principal.
We'll just submit the written submissions minutes. And the citation system.
Intimidating. Written submissions.
Minutes, one particular judgment runs into about 120 pages that contributes to the bulk. But I believe minutes, my written submissions would be brief as they are required.
Yes.
And we try to encapsulate whatever that's been argued in all 4 occasions. And we would not be troubling your lordships again reading everything minutes. It's only a reply. I'm conscious of it.
Yes.
Both my lords have the written submissions minutes. Minutes at the very beginning, I've set out initially at page 51 of the writ petition minutes. They have qualified me with a brief communication. Thereafter, minutes, it was followed by Ashoka's notice and my reply as well. That's the first page minutes. Now, my lords may kindly come to the second page minutes. Here, we have just set out, indeed, minutes. We made our submissions on these counts. My lords could see the next second page minutes. Legal submissions, one with regard to maintainability. Minutes, we have relied on the decisions that have been listed below. To have ease of reference and access minutes, we have even given the paragraph numbers in the brackets minutes, both the compilation and also in the written submissions. And beyond that, if there could be anything minutes, but what I felt is that minutes, these are the paragraphs that may have some light to throw on the controversy, legally speaking minutes. Then minutes, we have come to the other one, the levels of judicial review in contractual matters.
Yes.
Minutes, here also minutes, we have set out the very known judgments such as ABL International, Papatrao, Venkatrao, and Century Spinning minutes. Then minutes, we have also set out the distinction that could be made between the threshold adjudication and post-contractual adjudication. And my lords have held that when it comes to threshold adjudication, the court scrutiny would be more intrusive. That's what we prayed for before your lordships now. Then minutes here at page
4, my lords could see C, that paragraph C minutes, where the latest judgment has been referred to MP Power Management Company Limited minutes. It runs into about 120 pages and minutes, and we have listed out the areas just covered. And I must say, minutes, it's a painstaking judgment that has taken note of all the decisions that have been rendered up to that point of time. The contractual matters, writ petitions, arbitrariness, public interest, and all these things have been covered. That's why a one-stop reference that could be for my lords. That's why we have kept that 1 minute. Then minutes at page 5, my lords could see interpretation of contract in the course of judicial review. Minutes, since the other day, a question fell from my lordships that when I was trying to impress upon your lordships with all foreign judgments, that when it comes to interpretation, my lords have queried that when it comes to interpretation in the judicial review, what could be the expansive scope of such an interpretation? In that context, I've cited a couple of judgments. Incidentally, they've reached the Honorable Supreme Court and they have all arisen out of writ petitions, and where the clauses have been interpreted and they've said if it leads to perversity and absurdity and commonsensically it offends the notion, then it can be interpreted and interfered with. That's what their lordships have said, my lords. That's why I've just quoted all of them. Then, my lords may kindly come to page 6. My lords, interpretation and ambiguity, my lords. This is where I actually stopped the other day, my lords, in my reply. My lords may kindly recollect, my lords, it was heard quite repeatedly said that when it comes to ambiguity in any clause to be interpreted, my lords, what's required to be looked at is the perhaps interpretation given by the author of the document. And my lords, I was submitting that it can't be, because it cannot be subjective, it ought to be objective. And I may have whatever the intention, once I reduce that to writing, only that should speak, not me. I cannot lead any sort of parole evidence or justification. Post-contractual conduct by way of even correspondence cannot come to rescue, my lords. And my lords may appreciate that when it comes to contra preferentum, if there were to be any dispute as to the meaning of a word, it should always be resolved against the one who made it. That's why, my lords, that's been set out in a couple of judgments by the Honorable Supreme Court. That's what we have done, my lords. Now, my lords, we have taken, thereafterwards, at the bottom of page 6, we have taken the contentions. Each contention, my lords, as raised by either opposite party number 1 or opposite party number 2, and we have answered them, my lords. Perhaps my lords could see, just as a matter of a case in point, my lords, we have just had that one. First, they say that what is meant by an associate, how the PCMPL being an SPV affects my rights. That's been answered, my lords. Then the next contention with regard to, my lords, how there are directors on the board nominated by us. And, my lords, they try to impress upon your lordships, my lords, as if we have had common nominee directors on these SPVs. It is not, my lords. In fact, being the minority shareholder as I am, 49%, I've had my director nominated. They have, the other side have their directors nominated. That's how it has become. Even when it comes to, my lords, the consortium or joint venture, companies act through the directors. They come together, and then even the documents they have signed together, directors nominated by either party, even with regard to opposite party number 2 and me in 2 of the ventures, one continuing still. That's why, my lord, there isn't much of a difference whether a director nominated in SPV or director nominated to be part of consortium, my lords. And more so, my lords, when it comes to an SPV, it has a limited remit, because that director cannot travel beyond that SPV. The moment that project is complete, that ends, it loses its existence, nor can it come out as an independent entity and be a bidder, any process of tender, my lords. That's not possible. Whereas a consortium or a joint venture, they are in the nature of partnerships, and they could continue, they could bid, they could participate. That's what even RFB has said, my lords. It's like a partnership firm that could be done. And I've given a lexical clause, a sheet, my lords, on the last occasion, where they have all been defined through various either statutory provisions or lexical meanings, my lords. That's why, my lords, I'll not be troubling your lordships, but these are the answers we have submitted to the queries they have raised, my lords. And, my lords, then their trump card, I'll come to, my lords, that we have been connected through a common third party. This is all they have been telling, my lords. placing reliance on 2.2.1 clause 5 minutes. That's where they've been trying to impress upon your lordships. I'll just read that clause and leave for your lordships' kind consideration. Thereafter, my lords may kindly see minutes. Here, kindly come to page 9 minutes.
Yes.
Minutes we have filed. There is an extract minutes. Just below, above that extract, we have referred to the tender referred to in serial number 4 of table, page number 9 of rejoinder. Minutes we have filed a rejoinder, and there we have set out the instances where all three of us earlier regularly participated in bidding process and we have never been disqualified. And then minutes the answer part came from them saying that no, each has a different clause. That's why if there were to be any conflict of interest clause, it could have been different. May I just crave your lordship's attention to just have a look at that rejoinder minutes where we have set out the table minutes. Kindly have a look at the rejoinder minutes.
No, but we need to keep in mind
yes,
that whatever we have to decide,
yes,
we have to decide in the context of the present tender process.
Yes, minutes.
We cannot.
Yes,
this is my prima facie view.
Yes, ma'am. Please.
That we cannot decide the dispute based on the earlier decision
yes,
which might have been taken wrongly or rightly.
My submission is twofold, minutes, for that one. What I would like to submit is this, minutes. The understanding of opposite party number 1.
That you are there, you may be correct.
Yes. Vis-a-vis this has been consistent all through. For the first time, they take a U-turn for an obvious reason and say that it is otherwise. Had it been minutes of the same terms, and in fact, they've gone on saying in their reply, no, they are different. For that purpose, minutes, kindly have a look at the same page instead of going to that one. At page 9, there is an extract, minutes.
Yes.
Could my lord see the extract?
Yes.
A bidder may be considered to have a conflict of interest with one or more parties in the bidding process if A, they have controlling partners in common, or B, they receive or have received any direct or indirect subsidy financial stake from any of them, or C, they have the same legal representative agent for purposes of this bid, or D, they have a relationship with each other directly or through common third parties that puts them in a position to have access to information about or influence on the bid of another bidder, or all such bidders have a conflict of interest, shall be disqualified. Millets, in the table, we have shown as item number 4, and that is the one where all three of us have participated with this condition. Only to show Millets, twofold Millets, their understanding was right to begin with, and now they would like to have a wrong spin on it. This is my primary submission, Millets. The second thing is that, Millets, it smacks of arbitrariness. Taking a turn, taking a stand as it suits their convenience, now and then. These are the two submissions, Millets. My lords, I just bow down to the proposition that just because they have made a mistake, two wrongs cannot make one right.
We are not saying that.
Yes.
We need not hold.
Yes.
That was a mistake.
Yes.
You are relying on a decision to question the decision in the present tender process. So we shall confine ourselves. We shall, yes.
The contemporaneous expositor principle, how they have understood.
Yes. For that purpose,
yes.
That how that clause was understood by you,
yes, ma'am.
In the previous tender process, that may be a reasonable submission.
Yes, ma'am. Because Millets, with a straight face, they've said that we have never violated, and they've said that no, those things did not have that condition. That's for that purpose. It's only vis-a-vis OP number 1, the shifting stand to expose that one. I've submitted that one, Millets. Then Millets. Everything boils down to only two things, Millets. All this discussion comes to only that one. That's what we have set out, Millets. Finally, Millets, without troubling your lordships, kindly have a look at page 9900. That's all. So that, Millets, this is what's been in black and white as I presented to my lords, supported by the decisions. They could be gone through, Millets. But the only thing is that, Millets, just to refresh your lordship's memory as to our stand, how that was sought to be diluted by the opposite parties, only for that purpose, Millets, kindly come to those clauses. There I leave my lords because it's after all my reply only. My lords, come to page 99 of my petition.
No, which this is 17188.
120.
Just
17120.
One seven one two zero.
Please mention. 171.
171.
Page.
Minutes, page 99 minutes. Well, let's have come to that one, miss.
Just. Yes.
Yes, yes. Kindly come to minutes. 2.2.1 is eligible bidders. And under that minutes, my lords may kindly come to B. Because minutes is based on their written submissions. I'm just making a reference because they've extracted this one, they've argued this is how it should be interpreted. I may put my version of that one minutes, just for my lords' consideration. A bidder shall not have conflict of interest. My lords could say that's B. Kindly come under that one. 1. The bidder, its member or an associate. My lords got it? The bidder, its member or associate, or any constituent thereof, and any other bidder, its member or any associate thereof, or any constituent thereof have common controlling shareholders or ownership interest. Here, Millets, my humble submission is this, Millets. These expressions assume importance. That is, Millets, common controlling shareholders. That means, Millets, if there are two bidders, and they should have had a third party element who has common controlling shareholding in both of us. That means, Millets, we become only a front or a facade for that unknown third party entity. It competes in different manners. Ultimate beneficiary would be that one. My lords, in automobile industry, my lords may kindly see that, my lords. When it comes to many of us, will take pride. I have bought Audi, I have bought Volkswagen, I have bought Ducati, I have bought Skoda, and all these things. And incidentally, my lords, they're all manufactured by only one entity. This is how, my lords, to avoid that front and other things, if somebody has investment in me and the petitioner in the other writ petition, and then he has a common controlling shareholding in both. So, Millets, either of us will have something, Mills, ultimate beneficiary he is. Then, if both of us come and compete as a matter of a show, then it amounts to cartelization because one has to undercut the competition of the other so that others won't enter. In that context, Millet has been said in my humble submission, and common controlling shareholders. Neither of us has any common controlling shareholder, Millets. Then, Millets, it's been said, other ownership interests. Millets, ownership interest that could dominate to the extent of influencing decision-making process, not somebody having 10 shares or 5 shares, even that's not available. So, Millets, these two things have to be read in my humble submission, use them generis. They're not disjunctive expressions. They mean one and the same thing, that that entity should have invested in me as well as in the other entity. And that's being the common benefactor of these two entities. There is a conflict of interest, Millets. That's what I would like to submit. Then, Millets, what's been said later, a proviso has been appended. Millets, with great respect, once I'm out of the principal clause, the proviso, which only helps me, may not be required to be referred to. This is my submission with regard to this common controlling factor, Millets. Now, Millets, the other one they've been laying much emphasis is that, Millets, that's of next page, Millets, that's 100, clause 5.
Yes, that is the crux.
Indeed, Millets, I'm coming to that. May I just read that? Such bidder, its member, or any associate thereof, has a relationship arising due to ownership, holding, cross-holding, Millets, with another bidder, its member or an associate thereof, directly or through a common third party. So, Millets, I should have control over the other competing party through a common third party. That means, Millets, I'll submit. I am an entity. I cannot directly invest in another entity.
No, it does not say control.
Yes, Millets. Yes, Millets, I'm coming to that one.
Relationship.
May I come to that, Millets? such bidder or its member or any associate thereof has a relationship, right, my lords? Has a relationship. How does that relationship arise? That's the question. My lords may kindly see. It could be either due to ownership, right, my lords? Due to ownership. Then holding. Then my lords, cross-holding. In which one, my lords? In the other bidder. In the other bidder. By what means? Through a common third party. These are three expressions, my lords.
And there is one very important expression.
Yes.
That is access.
Yes, my lords.
Position to have access.
Position to have access.
Information.
Grateful, my lords, for reminding. I am coming to that one. So, my lords, let me have this clarification. First is that, my lords, one entity is there and the other entity is there. There should be a relationship between these two entities. By what means, my lords? Either ownership or holding or cross-holding. And this will happen either directly or indirectly. Right, my lords? That's what's been said there. And this indirect method, let's talk about, because direct, it's been overruled. There's no direct investment on either side. So there should be a direct investment, indirect investment. That's what they say. Who is this common third party? They say this common third party is the SPV. It could be TCMPL or it could be PCMPL, either of them. So this is a third party. That means, my lords, the circuitous method I could explain for my lords' convenience, my lords, that I cannot directly have any holding, cross-holding, whichever way we call it, ownership interest in the other entity. Then I float a third-party entity and that invests in turn. So this is the route that has been prevented. Then, my lords, what's been said, if having that one is not alone sufficient, that should facilitate me be in a position to have access to the other side. My access to the other entity through a third party, then it determines that it is a conflict of interest. I hope, my lords, I've made myself clear. Now, my lords, what's the meaning of puts them, either or both of them, in a position to have access? This is the crux. How do I have access to them? This is the position. My lords, this position is not a simple lexical word. It is a word of art. In corporate terminology, it has a particular significance. May I draw your lordship's attention to, my lords? I'll just read out from Ramnath Iyer's Law Lexicon, 5th one. Just minutes. Well, it's page number 5205. Latest edition of Ramnath Iyer's Lexicon, minutes. 5205.
Yes.
Minutes. I just read out, minutes, since I've not supplied the copy to your lordships. I may be pardoned. I'll be supplying minutes. Just I would like to read out whether it's a word of art or a simple lexical word. An investor's stake in a particular share or market, the number of shares owned, long position, or the number of shares owed, short position. As a verb, the term to take a position means to acquire a net inventory, long or short, in a particular share. If the investor has bought 1,000 shares, he has built a long position, whereas if he has sold 1,000 shares, he does not possess, as has taken a short position. This is what's been said with regard to position in a corporate terminology. Whether it has been reflected by any other lexicon, minutes, I'll go to Black's Law Dictionary. I'll just show that minutes. Volume 2, minutes. I've divided the two, though it's a single volume. Minutes, it's at page 1406. Volume? No, single one. Black's Law Dictionary. Okay. Page number 1406.
Yes.
Millers. What's been said? Position, Millers. The extent of a person's investment in a particular security or market. This is what the meaning of this position, Millers. Now I'll come back to the reference. Millers. When it comes to this expression, Millers, such bidder, its member, or an associate thereof has a relationship due to ownership, holding, or cross-holding with another bidder, its member, or an associate through a common third party. That means, Millers, if this SPV becomes a common third party, then the relation must be between me and the petitioner and the other petition. So that common third party must have invested in them. I too must have invested in that one. This is how the route is completed. Then, Millets, It is not something like eavesdropping or two directors working together, have friendship, and that's why they could share information. This is what they would wanted to, your lordships, to take that note of. That, yes, look, there is an SPV, they work in close sync. That's why they'll be chit-chatting and they would be sharing the information. This has been prevented. Well, let's see, if that were to be that simple, even in a consortium, even in a joint venture, all these people come together and work, and they could have had equal access. That is not what meant. I should have access legitimately, because once I become a shareholder in the other entity, I can demand information from them. Or if the third party, the facade or front I have floated, if it has invested in this, I can ask it because I'm the boss of it. And it can in turn ask them for the information.
There is difference between consortium and SPV as a company.
Yes, Menace.
So it's a SPV itself is a body.
Yes, Menace.
Corporate.
Yes, Menace. May I answer that one? Menace, SPV, if at all, it has the ability to participate in other things. Still, it shuts down for whatever oblique motive and then floats somebody else to do that task. It comes. But here, Millets, this SPV is a standalone entity which has come into existence with a particular objective, and it cannot travel beyond that one.
No, you are right.
Yes, Millets.
But it's a company.
It is a company.
It's a company of which...
Provided, yes, provided this company has any investment in the other entity which I control through this jockey. That is the purpose of that one. That's in my humble submission. Yes, it's a company. I've invested in that one. That company must have invested in that company so that I'll have access to that company through this one. My having access to SPV, their having to SPV is of no consequence.
It is not that you must be having access.
Yes, Millets.
You may not be having access, but you can have access.
Yes, I should have, or rather, I must be in a position to have access. That's why it's been said, Millets.
Exactly.
Yes, I must be in a position to have access. How can I have access to B, entity B, my rival or my partner in crime? How could I have access? I should have access through another entity, a common third party. That means that common third party must have access to that entity. So I have proxy and I can enter through them, sort of a vicarious entry. And here, both of us have come and confluenced on an SPV, created that for a particular purpose. And it can't travel, nor can it demand me for any access, nor can it demand the other party for any access, because it's entirely a different one.
Yes.
That's why, Millett, that's been said, being in a position means being in a legitimate position to have access. That's why they said, if you're an investor, either directly or indirectly, in the other entity, you have an access. You are in a position to have access. My lords have rightly put it that it doesn't mean that I should have access. I should be in a position to have access. If the possibility is there, then the alarm bells must ring.
So when this, we have to read this expression.
Yes, Millets.
That puts them in a position.
Yes.
We should add legal.
Yes.
For the position.
Precisely. It should be legitimate and legal for me to have access.
Sorry.
Not that eavesdropping. Not that on the sly I could have it. If that is the case, the same position prevails even in consortium.
That can happen. No, that can happen even otherwise. Without
any pally are close together in a working atmosphere. For that purpose, I have said, Millets, what's been said is legitimacy. Then only it strikes at that one. Yes. That's why, Millets, they have used the expression impression of suspicion. Millet, in their counter. And I say that, Millets, what's been said here is it's a matter of legitimacy, not the matter of my snooping. Millets, this is how my lords could have read quite an interesting, I will not take much time, Millets, only 30 seconds for this one. Millets, in a company, a German company has come out to India, has tried to outbeat all other rivals, but it went back, unable to compete with this one. And the rival smart company, what it has done, Millets, whenever they have landed in Delhi airport, they have ensured a driver would be taking care of them. Because they have taken him, he knows German. And those people never knew he has the German. So throughout the car, they would be discussing the plans. By evening, you would pass on the information to the other side. This is what illegitimacy. It's not in a position to have access to the information. This is how corporate coups happen. That's a different story, Millets. So, Millets, what my submission is here, here, this SPV, they say on the one hand, is the arm of the other party. On the other hand, they say it's also a common third party. It can't be either. If it's an associate of one, it protects me saying that since I'm a minority investor, less than 50%, I can invest in that one, it's legitimate. The others, they may have a defense vis-a-vis why they have 51, how that affects or doesn't affect, not my ballgame. When it comes to this one clause permits me to have investment in a situation where I cannot control it. And what the expression they have used at Miller's, virtual control. It's something like virtual possession. There's nothing like virtual possession or virtual control. Either a legal control. To have that legal control, I should have more than 50%. I do not have. That's why it's not my associate. Once it is not my associate, it's legitimate for me to invest in that one. Can, in the same RFB, another clause defeat and take away this provision? They have to be read harmoniously. For that purpose, what they have said is that, Millets, the access must be legitimate and that third party must be the investor in the other party through whom I can jockey the information.
Yes.
Millets. That's why, Millets, in my humble submission, neither this 2.2.1 B1 or 5, Roman 5 Millets, will have no application, Millets. In fact, opposite party number 1 all through has rightly had this approach. Then, Millets, perhaps wisdom or miswisdom has dawned upon them that has led to this perversity. Millets, as I promised Millets, I have taken about perhaps 20 minutes. My friend promised the other way 3 minutes. It's up to him. Yes, Millets.
Thank you.
And more so, Millets, there are limitations when it comes to SPV because it's bound by law. It's a juristic person, as Millets have pointed out. When it comes to consortium, it's loosely constituted one. And Millets, they can bid, but whereas the SPV cannot bid. Grateful for the opportunity, Millets. We know, Millets, perhaps fifth time we have troubled your lordship, a learning experience as it has been. Great.
Thank you so much. Yes.
I will be very short and very brief. So one thing, my lord, I want to first say, my lord, that in rejoinder, both my friends have introduced new material in terms to back up their argument.
One more question, Mr. Naidu.
Yes,
what is the effect of that communication through email made by you?
Yes,
where you said that, all right, you return my this thing security and don't blacklist me.
Yes,
had you not agreed by the said communication?
Millets, may I submit Millets? 2 things I submit here. One, it is a list pendants development. Ultimately, my lords may have a decision on that one. And the second one, Millets, given my bargaining power, can I say no to them and get away with that one? I have to face them every day in and out.
So according to you, what is the impact of that? That communication, whether that has some impact or not?
I reckon, Millets, that may have to be taken as without prejudice. In fact, Millets, the effect of that was debarring us for the next 5 years to come. Virtually, our existence disappears with all the investments. And we need to buy peace to the extent of disqualification, disbarment.
So here the disqualification, they have not,
No.
that still is there.
Yes.
So they have not blacklisted.
Yes, Millets.
No, they have
only with regard to blacklisting they have done. Forfeiture also remained. That's how it is.
So I don't think that is list pendants, subject to correction. Your lordship is please. Yes, 19/12/23. This honorable court passed the judgment.
the expression used by the Honorable Supreme Court while remanded the matter is restoring the petition. Once it's been restored, it's lis pendens.
Yes.
At the time when it was made on 3rd January.
3rd January.
After the judgment. And my lord, it was hearing was given to them on 24th January.
Yes.
And thereafter, my lord, they wrote another letter on 8th of February, which they have annexed at page 66 in their writ.
If I may put it,
and on 12th of April, no, I'm just giving those 4 dates.
Please.
And on 12th of April, the order was passed as a one-time concession.
Give the reply.
After having heard them on 24th January.
Thereafter, they filed
the SLP was heard thereafter.
Filed thereafter.
No, it was filed. No, it was filed on 15th March.
15th March.
I cannot say
I stand corrected.
It was filed on 15th March, but it was heard on 28th April.
Yes.
It was heard on 26th April.
By the time
this order had already been passed.
Since my lords have raised that question, only one sentence, my lords. My lords may kindly say para 10 of the Supreme Court judgment. We accordingly allow the appeal and set aside the judgment and order dated December 2023 and restore writ petition number so and so. Once it's been restored, my lords have seen many a time, even matrimonial proceedings, somebody gets married after the divorce, once one particular court gives, and it's been challenged and restored, it's suspendence doctrine.
You have one more difficulty.
Please.
This court's judgment was set aside on the sole ground that it was bereft of reasons.
Yes, please.
Therefore, are we not required to decide on the basis of whatever was there before the writ court when the judgment was delivered?
Yes, ma'am. One moment, minutes.
No further pleadings, nothing, because that will amount to.
Kindly see, Millers. May I just read para 9?
Yes.
Finding an absence of any reason, the judgment of the High Court on the merits of the issue of disqualification, we remit the proceedings back to High Court for fresh decision. We clarify that we have not expressed an opinion on the rival submissions which are left open to be decided by the High Court in a reasoned judgment. So, Millers, I believe, Millers, in my humble submission, it's been a clean slate, wiped off, and sent back to your lordships to adjudicate afresh. It is not a sort of a limited remand saying that one, take the arguments as have already been done, and then only supply the reasons. If that's the case, this exercise could have been.
You can say this in a different way.
Yes,
it has not been remanded back to the court just to assign reasons for dismissal.
It cannot be in my humble submission, Millers. They have said that we are not expressing an opinion, and then it has to be decided afresh. For that purpose, Millers.
Yes.
And Millers, what they have done vis-a-vis this blacklisting is that, Millers, when I have given my reply to the show cause notice, that has been decided, that has happened. Not that, Millers, I abandoned these proceedings and undertook them that I will not be litigating further. No such thing has happened, Millers. Great.
A very short mission. And I understand that the learned additional solicitor general is just on his way, he will also finish. So, first thing that I wish to say, Milord, is that it is a settled practice, Milord, that in rejoinder, no new material is placed before the court. You are only replying to what we have argued. But new material has been placed for the purpose of interpretation, which, Milord, I would say your lordship will take with that objection that we have taken on this, Milord, without saying anything further, because I don't want to be technical about it. Because I have a better case rather than being just a technical matter. Now, Milord, I am replying, just giving a few points, Milord, on what has been argued first by Mr. Vikas Singh, and then I will just go to Mr. Naidu.
Yes.
Milord, Mr. Singh argued a lot about malice. There was not a single line of pleading in the writ petition on malice. There is none.
No, but he has submitted that
Malice in law can be taken up at any time. I am submitting, my lord, there still has to be some pleading, even on malice in law. Because when you allege malice, even if law, the word malice has a different connotation, my lord, against an authority. He's saying, I am not saying anything against anybody. But the malice is what is there, the MCL did. The malicious act is alleged against the tenderer.
If you deviate from the prescribed norms,
Please.
legal norms,
Yes,
then that is malice in law.
no. So if you deviate from that, so that would be attributable only to MCL, my lord.
Yes.
It can't be anybody else. So I am only respectfully submitting that it is against MCL. So to that extent, there will be a line that the MCL acted with malice by deviating from these norms, and therefore there is malice in law.
Yes.
That one sentence should be there.
Cannot be against you, you are right.
But so there, it can't be, my lord, just in the air, my lord. In my respectful submission, at least this one sentence should be there in the writ petition. That is my respectful submission. So that is why I am submitting. There is no pleading. Then, my lord, insofar as the other point that my friend argued, my lord, is with reference to the High Court judgments which I relied upon. My friend said that they are all correct. He is not doubting or not distinguishing. But he is saying my case is distinguishable. I am respectfully submitting that neither of those judgments he has shown, my friend has shown, why those judgments are distinguishable. They are not one of them. He told about percentages that less than 6%. There was the case in the Delhi High Court. But here he has 51%.
Yes.
Now, my lord, the third position, my lord, is that what my friend, both my friends, with all due respect to them, have not answered, is that the addresses of both the SPVs, TCMPL and PCMPL, and NCC is the same. So the position to influence can be inferred by the fact that they are there in the very same building and their registered addresses are also the same under the company MOC, Ministry of Commerce, Ministry of Company Affairs. So that my friends are saying, I cannot have a third party, or a third party will not fall within the clause of 2.2.1b. I am respectfully submitting that this aspect, which is one of the things which led to the inference by MCL, apart from the directorship being common, apart from the shareholding of 51 and 49%, is also the fact that they are located in the same building. Now, my lord, one more thing here. My friend, in his written submission just now, which he has filed, at page 8, my written submission filed by Mr. Naidu just now, my lord.
Yes.
Lord, what he's saying is that NCC is an associate and as PCMPL and TCMPL are an associate. Page 8, Lord, the first bullet point at the top.
Yes.
So what he's saying, Lord, that NCC will definitely come within that because of 51% and because of the fact that NCC Limited Associate, PCMPL is said to be a common third party, as agreed by opposite parties themselves. Both PCMPL and TCMPL are the NCC associate. Evidently, petitioner with 49% has no control.
Yes.
So I am saying, my lord, that insofar my friend says that against the other bidder, that NCC cannot be anywhere in the picture. So this is only in this regard, my lord, with reference to that common address argument. Then there was another argument of Mr. Singh that here also an SPV is formed. The requirement under the contract which I have signed subsequently, my lord, in February with the MCL, it requires that
I have to form an SPV. So the SPV has come later. There was no existing SPV from before. So, my lord, that similarity is not there. There is no similarity of the fact, because my friend said that SPV has to be formed. That was the general argument. But SPV which was formed there, you have disclosed it. You disclosed it in your work experience. You wanted to take benefit of that work experience. And for that benefit, you have disclosed it. Now, if you have disclosed it, I also make another submission, my lord. There were pre-bid meetings. There were clarifications. I asked myself, why would my friends not make a query that I have such SPVs, they are working, we have been working together, will it have a conflict of interest? Lord, they could have very well asked at that point of time in the pre-bid meeting or a clarification. They never did so. If they had not made that query, some answer would have been given by the Mahanadi Coldfields. They did not make that query. It would have been the best thing, Lord. Today we would not have been litigating if they had been told then this will be conflict of interest. And you don't, but they didn't make that query. MCL never had an occasion to answer, Lord.
Could it not be that they did not have any doubt that they do not have any conflict of
Lord, so therefore, Lord, I am saying that if you are relying on an SPV where you admittedly say that 49 and 51%, then and if you read the clause, so therefore I am saying, Lord, that the interpretation that is being given by them is not correct to the clause itself. Lord, I am saying
Mr. Ranjit Kumar, their case is that there is no conflict of interest.
No,
and there it is and therefore, as sister has observed, that they did not have any such doubt.
No, but
therefore, why should have?
I'm putting it a little differently. What is the purpose? Sorry.
Yes.
I'm putting it a little differently. What is the purpose of a pre-bid meeting? What is the purpose of raising queries? What is the purpose of raising clarification, even if not no queries? Because you are relying on a work experience of your own company. If you are relying on a work experience of your own company, you might as well, whether I will come or not, because it's not that they are people on the street. They are getting into tenders, because they have shown charts after charts that we have been working, we have been tendering together. There were clauses, similar clauses there. Their whole argument is that we are being discriminated in this case and not in other cases. So if their whole argument is this, Milord, then Milord,
discriminated in this case and not in other cases. That is why they did not have any doubt that they would be
discriminated here. So therefore they would have to, the clauses are not exactly the same. If the clause is exactly not the same, then they might as well ask that what is the difference between that clause and this clause? Lord, I would say a person with some kind of evaluation, he would think that I hope this will not go against me. I will at least make an inquiry.
Yes.
Milord, the income tax, advance tax on rulings, what does it do? This is what it does. Your Lordship knows, Milord, the Tribunal on advance tax ruling does this only. You have a query, you go to the court, they give you a judgment. You go up thereafter, you carry on your affairs in that manner. Yes. Now, Milord, one more thing was addressed, Milord, by Mr. Singh, that reverse bidding and cannot be without any evaluation. So it can't be that the L1 will be chosen and then technical evaluation. But that is a statement made off the cuff, Milord. To say just that it can't happen. But it is so happening, Milord, and the affidavit has not been controverted that reverse bidding don't happen. To say technical evaluation would have taken place and then reverse bidding would have happened is something which is other than what the actual affair is. You do a reverse bidding, you come to an L1, L1 is a technical evaluation is done. If he is not qualified, you go to the next one. You again do a technical evaluation. That's the process given in their affidavit. The third thing, Lord, on this is that the reliance on those 10 companies with DB Buildcon. DB Buildcon has fortunately or unfortunately not bid in this tender. So all those examples which my friend has given has no legs to stand. Because it's not a bidder. And we will be on the price aspect, my lord. There is a judgment of your lordship of the Delhi High Court in the Jindal Steel Work case, my lord, which was affirmed by the Supreme Court on pricing, that you can't go into the unponderables. What could have happened? What would have happened? Your price bid is not opened. Where is the question of going into imponderables or unponderables, my lord, that to go? So that judgment we'll be placing, my lord, with our written submission, my lord. This is so far as Mr. Singh is concerned, my lord. Insofar as my friend Mr. Naidu is concerned, my lord, whom I hold in very high esteem, my lord. My friend has relied on judgment of Noble Resources and Popat Rao. Popat Rao was a case of refund of money.
Yes.
And the Noble Resources, that judicial review is more intrusive. Now, my lord, to explain the word intrusive, your lordship, the Supreme Court in Katina of Judgments has already explained what judicial review is all about. The intrusiveness of a judicial review can't be beyond what has already been explained, and my lord, the Chief Justice has already explained in Rose Marta, where in paragraph 40 to 47, your lordships have succinctly, my lord, outlined all those judgments and come to the conclusion as to what judicial review is. So my lord, to intrusive to be explained further or made wider, you have to go by what the...
No, more intrusive would mean as compared to post process. Before agreement, it should be more. It can be more intrusive.
Lord, assuming Lord, what my Lord is putting it, that it is before the process. My friend is arguing, Lord, I take it that the process was not completed and it should be intrusive. I am saying in that regard also, whether post or pre, question is, my lord, what would be intrusive?
Pre is compared to post. More pre is compared to post, and therefore it is more than post.
So pre, you can have a wider judicial review.
So compared to that one, slightly more.
Answer is the same. How much wider?
Or you can say less intrusive.
Or less. Let me put it this way, my lord.
Yes. Yes.
Let me put it differently. The answer of mine would be the same. Even if it was more, that the judicial review has an expanded meaning. All the entire meanings have already been so succinctly put in a Katina of Judgments, my lord, that one will be taking coal to Newcastle for the purpose of understanding that there is something more that is required here. And as I, my lord, respectfully submitted that in Rose Marta's judgment, your lordships have paras 40 to 47 clearly outline all those judgments and come to the conclusion what is the scope of that judicial review. So whether, my lord, it will be going beyond that is the question, my lord, and in my respectful submission, no. Whatever has been already settled law, unless my friend shows the no, this settled law is not right, it has to be little more. That is not my friend's case.
No, he cannot say that. It cannot be little more. It compared to.
Please.
Yes. Compare.
I do. If two things, post and
Precisely.
pre, if they are compared to, then one is less,
yes,
and the other is more.
So the limited as it
that bigger circle remains.
Even in a pre-process having been completed, the aspect remains the same. You can't change the nature of review. The judicial review, the outreach, let us put it, my lord, the outreach of the judicial review. Then, my lord, my friend cited this MP power management. This was a termination of a power purchase agreement.
Yes.
And, my lord, these cases were to the extent that they deal with judicial review, in my respectful submission, law is settled, my lord, that the statement of law will have to be seen in the context in which the judgment is delivered. That is settled law, my lord, from 1950s. It can't be. So if you are dealing with the power purchase agreement which was terminated and a judgment is rendered, my lord, on judicial review there, so you can't apply just because the facts are totally different. And in any case, they don't say something beyond what, my lord, the law is already settled. What your lordships have said, or what UFlex said, or what Michigan Rubber said, or what Tata Cellular said. Nothing, my lord, there is no divergence of opinion there. In all these, my lord, this Popatrao or Noble Resources or this, my lord, MP Power Management. And then, my lord, insofar as my friend, my lord, he gave material from England and Australian cases with reference to interpretation of contract, that how a common man would understand, my lord, the terms of the tender. It is my respectful submission, my lord, that in a market economy today, as it is, in commercial contracts, where the contracts are entered with open eyes, not by illiterates, not by common man, so to say, a 14,000 crore contract is not done by a man on the street. A man with technical know-how and knowledge of the economy gets into something like this, my lord. So, to import something from England and Australia for the purpose of understanding, my lord, their knowledge or their education or their system, and our common man, with all due respect, my lord, and I am not trying to cast any, my lord, aspersion on any common man in our country, my lord. He is very, very learned, and he is very, very today up to the fore today, as we can see from election results, etc. So he is not a man in that sense. But in understanding a tender, my lord, I definitely would like to say that a person, my lord, a common man's understanding, or in the commercial parlance understanding of people with technical know-how and people with all the kinds of consultants with them, we should not import what is, my lord, mentioned in those judgments, my lord. And the last thing, my lord, I only say is that the 2009 judgments my friend cited in 5 SCR is relating to pension regulations.
Which is that?
This is on the last date, my lord, my friend cited the last judgment, 2009 5 SCR, page 118, para 28 at 139. I don't know the name of the case. So unfortunately, I didn't have that was the last case you cited on that day. On 21st.
I'll just keep it.
Please. Just the citation. You can give the name of the case. So, my lord, I respectfully submit, my lord, that the interpretation.
Bank of India versus K. Mohan Das.
Bank of India.
Bank of India
versus Mohandas.
Oh, I am obliged. Very obliged to your leadership.
This is Miller's Bank of India versus K. Mohan Das.
Yes.
With regard to the interpretation, the subject objective of
That was relied on by Mr. Vikas Singh.
No, by my friend Mr. Naidu.
I didn't.
That was the last citation, my lord, before your lordship rose on the day or 21st of November. So, in my respectful submission, my lord, that the decision, which is backed by 12 people I had shown, my lord, who had participated in that meeting
in that
for the purpose of evaluation.
But that I relied on para 28.
28.
Yes, 28 and 29.
I said so. Para 28 at page 139 of the report.
20, yes, exact.
Yes.
28 and 29. 30.
So, my lord, the evaluation, as I had shown on the last date, was by 12 people of different heads, my lord, who had all the knowledge and wherewithal of the Mahanadi coalfields, which came to a decision, my lord, that they had to be disqualified because they understood that there is a conflict of interest. This is how I'll put it, my lord, and in that light, my lord, your lordship will kindly not interfere, my lord. Very obliged, my lord. I'm very obliged for a very patient hearing to me, my lord. Grateful, my lord. And to all of us, my lord.
Yes.
I told them that Mr. Nataraj is on his
Just
way.
one thing to add, we have a common stand, all the submissions have it. But I would just request the lordship, Lord, one thing, that the remand order, as they say, they have shown the Supreme Court decision that remand order goes back to the date. Our humble submission is that materials which were available on 15/12/23 till 15/12, that is the scope of the remand. You cannot expand it. I'm not saying that the Supreme Court has said that you give reasons, your lordship will just give reasons, and not that way. It is open, and your lordship have been gracious enough to hear us at length and make our submissions to the full. But still then, the materials as on 15/12/20, you cannot expand, go on expanding your pleadings, go on expanding your scope of the writ, and by rejoinders, the lordship must see how many rejoinders, how many reply affidavits have been filed.
This is what I
in this case.
No, but was there any bar?
No, there is no, my whole submission subject to your lordship's consideration.
No, this your, in fact, we are also trying to understand this aspect. That whether after the matter was remanded back, whether the court could not have entertained further pleading on behalf of the party.
The stand which was not taken there, will it not expand the scope of it?
There you may be correct. That they could not have.
That this is bad for this reason. They are not taken. They are not taken here. And no pleading, as my learned friend rightly said, let us say legal malice. At least somewhat, some indication. Nothing is there.
No, legal malice can be argued also.
I followed not, can be argued, but some indication at least, that some indication, some in the pleading, that part is totally absent. That's right.
Yes.
I have no right of audience in the matter. I have no right of audience in the matter because I concluded. So I do not want to take an exception. This is the question is well settled. Therefore, I do not want to expand, but only one sentence what I can say, on the basis of the documents, the authorities have taken a decision, they have interpreted and come to conclusion. The judicial review of particular action, that alone is the consideration of the entire matter. That's all, nothing beyond that. I am not interested in the rest of other issues between two competing parties. Lastly, one sentence I'd like to add in the matter, in the due respect, it's out of subject. One of the judgments, my friend also knows very well, it has been said, the judges have not fallen from heaven. That is, one word is quoted in one of the judgments. Now time has come, with the due respect, it's equally applicable to me. Delhi lawyers have not fallen from heaven. There are so many litigants and lawyers are waiting in the courts. They can't keep on expanding a particular matter beyond a stretch or limit, and to take such a liberty. However, this court has shown a great indulgence, and we are grateful for showing a great indulgence in the matter. I'm grateful. I do not want to.
Yes, may I have the indulgence to just submit our written submission by the end of the day today?
Please do it. Please do it.
It's ready, my lord.
Please do it.
It just has to be printed and filed in. But your ladyship had observed in the last date that your final written submission and no further. So we have it ready, my lord. We'll just file it by the end of the day. Today itself. Your lordship may give me that indulgence.
Heard.
Grateful. Very grateful. Obliged.
Petition mail at 1788.
Written notes of argument, if any.
We gave something.
The file.
I do. What are you giving?
Their written submissions.
Their written submissions.
Can we get a copy of that?
Yes, thank you so much.
Very obliged, no? Very grateful.
Petition mail at 17188. We are submitting the written note of submissions today, and I would only tell one or two sentences with respect to your lordship's revision matter.
Only one or
Please. Yes.
much has been said that the decision was taken after 3 months and so. I have given the date chart. In the date chart, at page 2, you will also see on 19/12/23 judgment was delivered at serial number 18.
Yes.
And immediately on the same day, on 19/12/23, serial number 19, we have filed an IA for stay of operation of the order of this Honorable Court because we are contemplating to move the Honorable Supreme Court on the very same day with a copy to the all the parties. Thereafter,
So this you did in under which provision of law?
that we have filed an application 151 evaluations. Because we have said that please stay. The purpose is.
See, when
No,
the
no,
petition.
I am not on that matter. About the maintainability of the petition, I am not saying. I am not arguing on the maintainability of the petition.
No
Next-
question of maintainability.
Next 28/12. 19/12 was the judgment, and 19/12 itself we have filed a petition expressing our desire to for getting the order suspended for time
But
being.
that was in bad taste.
Well,
That was in poor taste. When you file an application after the judgment was delivered, you file an application for a stay of the operation of the order.
Because we are contemplating to go to Supreme Court, it will
Whatever-
take time.
whatever you-
Because we have very much apprehended that they will take immediate steps to proceed. In fact, it happened on 28th itself.
Mister, how could you file this application for a stay of an order passed by this court under which provision of law? You could have filed an application seeking leave of this court to prefer appeal before the Supreme Court.
Yes.
You didn't do that. You sought stay of the order, and that too because
Application for review could be filed and asked, there at least a stay could be asked. And in view of this fact that we have moved the SLP, special leave petition,
No,
that petition was not
thoroughly.
necessary. But what I'm trying to focus on the point is, immediately within 9 days thereafter, on 28/12/23, letter of acceptance was issued. It's not that when the contract was entered after 3 months or maybe there, but letter of acceptance was given on 28/12/23 itself. That shows the intention. That shows how hurriedly they are trying
That
to.
could have been done on 20th. 2012-2023.
They are not that fast.
They must be
They have to
waiting for
take
the
a copy
judgment.
of the judgment. No?
That is not the point.
The next thing which I would like to point out.
All right, we will see your notes.
Yes.
All right, we must have.
Please. Grateful. I'll not be filing any written arguments, but I have
All right.
pointed out the legal. This.
Yes.
Well, it's,
Item number 5.
Yes.
Yes. Pass over item number 5.
I had asked them to join online.
Mr. Acharya, your officers are not giving instruction to your law officers, the officers of the government.
In this case, two instructions I have issued, but only response came from the OP number to the Deputy Director Mines. And today only the director has informed me that somehow it was placed before him today only. So he'll be replying to your lordship, sir, on online. He is available.
Where is Mr. Director? Why has this happened?
My lord, we have received this particular reference and please allow us time and I would be immediately reporting back within 4 weeks on the action taken
Not
from the
4
state.
weeks. Not 4 weeks. The matter is pending since long. Take a decision, whatever decision you have to take, but this is not done. That a law officer is writing to you and you don't have time to respond.
My lord, we will definitely do that and I apologize for...
No, but why has it happened? Can you explain? Because see, that causes obstruction in judicial process. So why? Can you explain? Let us understand. It is not that we are going to blame you, but let us understand why has this happened?
My lord, that letter was addressed on 28th. In fact, it was placed to me today morning. On behalf, I take this apology. It is my duty to respond to, and I'll definitely see that we will be responding.
Mr. Director, it is good that you have understood it. Please develop a system. When any communication is made by any law officer, that must be placed before you on priority.
Yes, my lord, I'll ensure that.
No issue. We will not enter into that aspect, Mr. Director. But in future, it would not happen.
First order was 21st.
21st.
Yes, 21st letter has not been sent to him, that means.
Yes, 27th.
Mr. Ponda, we issue an order on 21st saying the matter will be listed on 28th. You dispatch it on 27th.
No, I drafted it on 25th. But it was somehow...
Mr. Acharya, your office and...
This is not the first time.
No.
Letters are being sent just before the date.
That
After
is
6
not
days.
Proper, Millard. I just came to know about
Just we are not. We don't want to enter into all these small things. These are small things. We get worried when we are informed that the officers are not responding. It is not that the officer is intentionally avoiding, but it is a matter of concern for the court. This can be resolved. This should be resolved, and in future it should not happen. That's all.
Well, it's just one submission, like to bring to your lordship's notice. There were 106 sponge iron units, industries which were set up in the state. Because of this activity, 44 have already closed down. I am also on the verge of being closure because I don't have any materials to run the unit. So, I'm seeking your lordship that your lordship may make some arrangement so that I can at least run my unit.
No, how can that be agreed?
No.
Okay, it's your policy that you
Let them take a decision. Let them take a decision.
Interim arrangement can.
Your lordship, but I have just put forth my predicament, my precarious state, my lords. It's already gone into recession.
All right. You file your affidavit.
Yes, my lord.
You take a decision or file an affidavit. You have to. If you,
my lord, please allow us 4 weeks time, my lord. We will definitely take a decision and we will report back immediately.
My unit would be closed, my lords.
No, but you are not getting the
pending with him since July. Pending with.
Therefore, it is pending with them since July, and he is seeking further 4 weeks.
That would tantamount to closing down my unit, my lords.
Maybe, but when did you file your writ petition?
Writ petition was filed, well, I'll get the date. 13/11, I filed.
13/11.
I gave them sufficient time, my lords. It's not that
They'll have to be given an opportunity to respond.
Your lordship has been given them the opportunity. Your lordship has twice given them
Mr.
the
Mukherjee, you filed this writ petition and on 30th of November.
13th of November.
13th of November. And this is 2nd of December. You want an interim order without giving an opportunity to them.
The opportunity has been granted. My lord, it's their own policy. It's not that something which I am asking for.
That has been.
It is their own policy.
Order. That.
Your
all right,
lordship
Mr.
granted
Director.
very short adjournment.
2 weeks. This matter on. The director, Mines and Geology, has joined the court proceedings online pursuant to this court's order dated 28/11/2024. Full stop. He has informed this court that he shall evolve a system for the future so that the communications made from the office of the Advocate General are placed before him without any delay. So he seeks 4 weeks adjournment to file a response in the response to the presented petition. However, considering the nature of grievance which the petitioner has raised in the presented application, the matter is adjourned to 2 weeks. So, in the meanwhile, the opposite parties shall be at liberty to take a decision on the
application and annexure 1.
Petitioner's application, bracketed, annexure
P1.
Annexure
P1.
Annexure P/1. So, within first 5 cases.
Item 5.
Yes. Yes, Mr. What is your name? Sir. What is your name, Mr. Director?
Yes.
My lord, I am Rajesh Gopalan Nair.
Personal appearance of the director stands dispensed with.
Your lordship will only fix a date.
Fixed, you will get a date.
60.
Date you will get.
Okay.
Date is there, given the date.
16. See that at least it's not on the same day, at least following day. This has gone after 6 or 7.
5 days, yes.
21st, dispatched on 7th. The next date was 28th.
I was listening.
And this is not the first case. This is not the first case.
Yes,
Let me just find out what is this.
see, it happens sometimes, but we have to evolve a system, that's all.
Nowadays, also, Milord, that can be also telephonically communicated or WhatsApp. Milord, I will ensure that it reaches the officers in time. And electronic communication will also do, or mail also.
This sort of an order.
That's right. I will ensure that.
This writ petition was filed on the 13th with an advance copy to the state. And as per the system which was prevailing in the Advocate General's office, I do not know what it is now. The moment it is filed, it is immediately communicated to the concerned department.
All right.
That we don't know. Sometimes we withdraw the writ application also. So.
Yes, but the point is that
I think my Lord friend,
and the person to address, it is communicated the very same day. LMS is also there. They have access to the petitions. It is more faster now than what was being followed earlier. So
Yes.
please don't worry. That is
We will not go into such a.
It is more faster nowadays, rather. We have given them password, everything. They have access to all the petitions the very same day.
Yes.
Item number 30.
30, I think, Milord, that was mentioned in the first hour. Speaking in adjournment. First, okay. 16, that has already been adjourned and communicated to the other side. 31 was fixed at
16 January.
January.
Yes.
Item 31.
Mr. Jain is online.
May I please, Your Lordship?
Yes.
Lord, I'll just ask my colleague to hand over a list of dates and a note for the court's kind convenience. So I'll be able to place the matter with the help of the notes to assist my lords.
Yes.
Satya, have you handed it over to the court?
One copy is there, Mr.
Yes. Lord, kindly have for the, by way of context, the list of dates, the first page.
Yes.
Yes. 14th August 2001.
Yes.
Your Ladyship has copy of the list of dates? Yes. 14th August 2001. A renewal of the mining lease was executed in respect of the subject mine between the state and the petitioner for a period of 20 years to start with, and the remaining 10 years was to be executed thereafter in terms of the order passed by this Honorable Court in proceedings so-and-so, and my lord, a grant order was passed on 11/2/1999. This from two really is relevant. Petitioner sought permission from the Deputy Director of Mines to sell iron ore to Jindal Steel. 4th March 2004, the Deputy Director of Mines forwarded the petitioner's request to the Director of Mines, highlighting the revenue advantage which will accrue to the respondent state. This would happen as the petitioner was selling the run of mine ROM to JSP with royalty to be paid at the rate applicable to the highest quality of iron ore, that is 65% Fe grade. 27th March 2004, the Director of Mines directed the Deputy Director of Mines to grant petitioner permission to sell the iron ore ROM to JSP, subject to fulfillment of certain conditions. 5/4/2004, this is the important document, I'll place it in some time. The Deputy Director of Mines permitted the petitioner to sell the iron ore ROM to GSP subject to various conditions, which included payment of the highest rate of royalty prescribed for iron ore of 65% Fe content for the entire quantity of iron ore which was supplied to JSP. And second, the weighing of the ore had to be done at the petitioner number 1's weighbridge in the presence of the government checking staff. 10th May 2004, the Deputy Director of Mines issued certain additional conditions to the petitioner for sale of this iron ore to JSP. Then from 2004 to 16, permission was granted to the petitioner. JSP also had applied for licenses under the Orissa rules for procurement, storage, and transport in the leasehold area of the petitioner, and this was periodically granted the same. The arrangement between the state and the petitioner was continuing in terms of the approval dated 5th April 2004, granted by the Deputy Director of Mines. The petitioner had also submitted annual and monthly returns as per the rules, both the MCR rules and the Orissa rules, to both the state and IBM. 31st March 2014, the state government passed an order directing the petitioner to stop mining operations at its mine. JSP was also directed to stop transportation of the royalty paid iron ore stored in the leasehold area of the petitioner. As on this day, my lord, on the day when the mining was stopped, 135 lakh MT of royalty paid iron ore was only stored inside the leasehold area of the petitioner number 1 in terms of the express permission given by the state government, and only lifting of the iron ore had to be done by JSP. Not kindly mark this date also. It's very important. The subject matter of the present case is this 135 lakh MT of royalty paid iron ore. These are the most crucial word, royalty paid iron ore. Then 9th April 2014 and 12th May 2014, representations were made by JSP before the state government seeking permission to continue transporting of the iron ore, which was legally owned by JSP. The state, though admitting that the iron ore was legally procured, processed, and royalty had been paid, rejected it on the purported contention that transportation was part of mining operation, and as the mine had been closed, JSP cannot be allowed to transport its own material. 25th April 2014, the CEC constituted by the Supreme Court submitted an interim report categorizing mines into different lists based upon whether the mines possessed the necessary environmental clearances. The petitioner's name was wrongly placed at serial number 9 of the list, then the list comprising of 102 mining leases, which purportedly did not have statutory clearances. So, the MOEF itself, by a letter of 15th May 2015, had clarified that the 2004 environmental clearance was a valid EC and was subsisting for a period of 20 years. 16th May 2014, the Supreme Court passed an interim order directing that mines which are on the list will remain closed. However, it will be open for the mine owners to get the requisite statutory clearances and approach the court for resumption of mining operation. The petitioner's mine was therefore closed on 31st March 2014 and was non-operational. This was not challenged by JSP before the Orissa High Court, challenging the contention of the state that transportation of material is a part of the mining operation and denying JSP the power to lift what it had legally procured, processed, and on which iron ore royalty had already been passed.
Admission.
Now, my lord, one very important thing, that the state government issued a letter which is on 12th March 2015, which admitted that the quantity of the material lying at the crusher site within the petitioner's leasehold area was really the material which was owned, in which the title belonged to JSP, which was the buyer of this material. Then, my lord, against the order of 8/4/2016, state filed a SLP. Supreme Court then, my lord, rendered its judgment, etc., etc. Now, please have serial number 19. On 15 January 2020, the Supreme Court granted permission to the petitioner to resume mining operation subject to depositing 933 crores. 30th January 2020, the Supreme Court noted that in the light of the order of 15/1/2020, no dispute survived between JSP and the state government, and it allowed JSP to transport the royalty paid iron ore, which was lying within the petitioner's premises after payment of 933.6 crores to be paid by petitioner number 1. This is also significant, but I'll take my lords to the order. Serial number 21, 30th January 2020, in view of the order dated 15 January 2020, passed by the Supreme Court, the Deputy Director of Mines issued a letter on 30th of January 2020, allowing the petitioner to apply for removal of the iron ore which was royalty paid, as I already indicated, lying at the dispatch point within the premises of the petitioner number 1 to be lifted and transported by JSP to its plant across the country following provisions of the rules of 2007. And finally, on 1/2/2020, that is after 31/3/2014, mining operations at the petitioner's mine resumed with effect from 1st February 2020 after a gap of almost 6 years. 2nd February 2020, the petitioner was granted a permission to allow transportation of the iron ore, which was owned by JSP. In this permit, the opposite party has again admitted that the iron ore belongs to JSP and royalty stands paid on this. 18/4/2021 is the impugned order, which I place for the court's consideration, where the Joint Director of Mines passed the order directing payment of differential royalty, and on top of it, DMF, and on top of it, NMET, that is the National Mineral Exploration Trust, amounting to 634 crores, which is the subject matter of challenge. Your Lordship may only make a broad note of the fact that till 2014, 1,563 crores had been paid by way of royalty to the state government. Then we challenged this impugned communication in this honorable court. A conditional interim order was passed, and finally the Supreme Court at serial number 28, which is on 24 January 2023, set aside that direction imposed by the High Court to deposit an amount as a precondition for the matter. So that is not the sequence of events. Now please have part B. This will give my lords a full perspective of the facts and the submissions, and then I'll take the court through the relevant documents. Please have part B, which are my submissions.
Yes.
My lord has part B?
Yes, Mr. Yeah.
Yes. Now, my lord, kindly see. Lord, first submission will be that the impugned order was passed contrary to the principles of natural justice and fairness, since there was no show cause which was issued or any opportunity was given. And why this is material is, on this 135.04 lakh metric ton of iron ore, as I indicated, royalty had already been paid. That was about 682 crores, and title had already passed. Delivery was complete, contract was already completed. So this is nothing but an attempt for what I call second time royalty and a double dip, which is not permissible in law. And it was only a question of actual simply removal or transportation from there. Otherwise, constructively, it had already been removed on that day in terms of that 5/4 approval. So this natural justice point goes to the root of the matter, that had you given me a show cause or a fair opportunity or an opportunity to represent or a hearing, all these facts would have come to your notice, which was already on your record and which you did not consider at all. Then the judgment which I will come to. So the first point which you will argue is a complete standalone point of violation of the principles of natural justice and the impugned communication both being illegal and arbitrary. Now the second point for the court's consideration, sir. Delivery of iron ore by the petitioner to JSP within the leasehold area is constructive removal or valid removal in terms of the provisions of the Act and the rules. Now, why do we say that? The answer, sir, is on the right side. The petitioner had sold iron ore to JSP from the period 2004 to 14 within the leasehold area and duly paid royalty for this at the highest rate in terms of the permission. That is why, sir, in the list of dates I indicated, 5/4/2014 was a vital date. The payment of royalty was duly received and accepted by the respondent authority. Once the delivery of iron ore had been completed at the weighbridge within the leasehold area of the petitioners, the ore stood constructively removed from the petitioner's leasehold area. It is at this juncture that the petitioner paid the royalty and all statutory dues and taxes on this ore in terms of the Act and rules. So this is the point that I was indicating, the 682 crores which had already been paid. And there was no objection from the state, as I will show you through their entire documentation. All of this had already happened.
High Court of Orissa.
And I also place the order passed by this court, sir, in writ petition 12119. So this is the second point for the court's kind consideration, that the entire transaction was already completed, constructive removal had been there, and this was all royalty paid ore that we are looking at. Kindly have the next page of the note, para 3. In compliance with Rule 10 of the OMPTS rules, prior to sale of the ore, the petitioner had paid the requisite royalty to the state government, subsequent to which permissions in Form L were issued by the respondent number 2 to the petitioner for sale of the ore. Simultaneously, the buyer, that is JSP, had applied to R2 for shifting of the procured ore to its storage place, and accordingly transit forms were issued to JSP. After payment of the ore at weighbridges in the presence of government officials was conducted, transit passes were issued in Form M by the Deputy Director of Mines to petitioner number 1. Point 4. Valid removal of iron ore therefore occurred between the years 2004 and 14 after royalty at the highest rate on the same had been duly paid. The chargeable event for royalty at the time of dispatch had therefore already occurred in and around 31/3/2014, that is much prior to the cancellation of the trading licenses of JSP. The opposite party has not revealed the fact that the petitioner, after selling and delivering the ROM to JSP, had filed statutory returns. The assessment of royalty and other levies had been regularly verified by the Deputy Director of Mines on a quarterly as well as on an annual basis. In the present case, the specific arrangement, sir, that is at 5th April, which I had shown, permitted by the state government and the opposite parties, the ore was sold to JSP inside the leasehold area, and this dispatch was completed by establishment of a weighbridge at the point of sale and the appointment of a state government officer to monitor the transaction, as also the collection of due royalty applicable during the specific period when the sale was done. The entire quantity, sir, is 135.04 lakh MT, which I indicated, was only stored inside the lease area of the petitioner number 1 as per the express permission given by the state government. Now, next is very important. This is acknowledgement by the respondent itself. It is submitted that it is not the case of the state government that the petitioner did not pay royalty or paid inadequate royalty. On the contrary, the state government has made the following admissions regarding payment of royalty by the petitioner and the vesting of goods with the buyer JSP and the transportation of ore. First document I will show you, sir, is in the impugned order itself that will come to. Second is important. Letter of 12th March 2015. JSP had 3 stocks situated near to the crusher within the leasehold area of the petitioner. Then the Supreme Court order of 30th January that the buyer JSP can lift the already mined, processed and royalty paid iron ore lying at the dispatch point within the petitioner's premises. And notably, the entire resumption order of 30th of January 2020 following the Supreme Court order of 30th January. As per the order of the Supreme Court, you are allowed to apply for removal of iron ore that is already mined, processed and royalty paid, which is lying at the dispatch point within your premises, to be lifted and transported by JSPL to its plants across the country following the provision of the 2007 rules. Subsequent to the order of the Supreme Court and the resumption order, the Deputy Director of Mines a transit permit in Form L was issued to the petitioner on 2nd February 2020 by the Deputy Director of Mines. Form L is the statutory form in which the prescribed format and the Rule 10 for transportation of minerals. In the present case, a code was issued to the petitioner for transportation of the mined ore of the petitioner and dispatch it to the buyer, and a separate code was issued to the petitioner pursuant to the order of the Supreme Court of 30th January and the Deputy Director Mines letter of 31st January 2020 only for the transportation of the royalty paid ore which belonged to JSP by the petitioner on behalf of JSP. So, sir, a separate document altogether was given in respect of the subject royalty paid ore, which is the 135.04 lakh MT. This is a situation of the making of the respondents. If JSP itself had transported the material in terms of the order of the Supreme Court, no issue of payment of any differential amount would have arisen. But since the transit passes issued to JSP had come to an end with the passage and efflux of time, the opposite parties directed the petitioner to transport the material owned by JSP on behalf of JSP and using a separate code given by the DMF. Yes. Now kindly see what they endorse on the transit permit, which is that statutory form L. This number with this number. And kindly note, sir, the code number that ends with 7302. Whereas the other code which was issued for the petitioner was 7301. So the court would note, as I indicated, my lord, that there was separate for SMP for transportation of mined ore, and this was specifically in respect of transportation of this already royalty paid ore, which is 7302. I have just extracted at present for the court's convenience. Remarks. Royalty paid and all taxes paid iron ore in terms of the judgment of the Supreme Court dated 30th of January 2020 in appeal number so and so. This is nothing but an endorsement by the respondent itself, another acknowledgement that royalty and all taxes had already been paid on this iron ore and referring to the order of the Supreme Court. It may be noted that after the sale of ore to JSP, the character and nature of the ore was completely changed, as the ore no longer stacked pending removal, but only stored in the petitioner's leasehold area as a distinct property of JSP, which is noted and recorded the special trading license granted to JSP in Form D under the extant rules. 9. This Honorable Court, sir, which is the writ petition I was mentioning, by a judgment dated 8 April 2016 in writ petition 12119 at para 35 held that in terms of section 33 of the Sale of Goods Act, once the petitioner delivered the goods to the purchaser, that is JSP, after payment at the designated weighing bridge and payment of value thereof by JSP, including royalty and taxes, and the ex-mine sale and dispatch of mineral was completed. The next word is very important, my lord. Right, title, and interest in such property is vested with the purchaser, that is JSP. This arrangement, this contract, sir, attained finality as it stood concluded as far back as 2014. So we have a concluded contract in 2014. Delivery was complete, duly noted and acknowledged in para 35 of a judgment of this Honorable Court. The contract for sale between JSP and the petitioner had been performed, royalty had been paid, and therefore all right, title, and interest in this 135.04, which is the subject iron ore, already vested with JSP, the buyer, in 2014. It is submitted that this Honorable Court, in its judgment of 8 April 2016, that's the same judgment, my lord, which I referred to on the previous page, held that the interpretation of the respondent that mining activities and operations include transportation is misplaced and directed the opposite parties to grant permission to JSP to transport its entire processed royalty paid iron ore at the dispatch point, which is located within the leasehold area of SMPL. Yes. Now, my lord, in view of this, it is clear that the role of the petitioner on the direction of the state government dated 31st January 2020 in respect of transportation of the royalty paid iron ore owned by JSP and lying within the mine site of the petitioner is now only of an intermediary. It is noted that this situation had arisen only because of the directions and letters of the respondent, and therefore it is submitted. It is not a case of dispatch of iron ore by the lessee, but only transportation of iron ore by an intermediary. Now, this is crucial to understand that what was actually happening was transportation of iron ore, that also by an intermediary, in view of the fact that the transaction stood concluded between the buyer in 2014. The petitioner sold 56 million tons to JSP in this period from 2004 to 14, and 1,563 crores was given to the state government as royalty at the highest rate, whereby 838 crores royalty in excess was received by respondent number 1. The respondent, therefore, is stopped from demanding double royalty, A, having granted permission for sale as far back as 5th April 2004, and having demanded royalty of the highest value applicable to the highest grade on the entire iron ore, and 3, having received the entire royalty on the iron ore more than 7 years back in 2014, and having passed an order of assessment on the payment of royalty. So, my lord, for these reasons, we say that this impugned demand is illegal without application of mine, is contrary to the directions given by the Supreme Court, their own acknowledgements, and the 8th April judgment of this Honorable Court. The next part I'll come to later, but in one line, if no additional royalty is payable, there's no differential amount, then the NMT and DMF is calculated on that basis. If the foundation goes, the superstructure on top of it will fall. Apart from the fact that this was introduced only in 2015, so in any case would not apply retrospectively to this. Is a separate standalone point. Now, my lord, I'll take my lords to the documents so that I can make this good. Kindly, my lord, have the most important document of 5/4/2004. Sorry, I'll start with 27th March 2004 at page 62. Now, this should be annexure 4.
Yes.
It's a typed version of that.
Which page?
Page 62.
Page 62 is the typed copy.
Annexure 4 level.
Yes.
Now, my lord, kindly see the date 27th March 2004.
Yes.
My lord will get it right below Director of Mines, and it is addressed from the Director of Mines to the Deputy Director of Mines. Kindly have the content, my lord. Third line.
Yes.
Sharda may be allowed to supply raw material on X mine basis within the leasehold area to JSP in accordance with the provisions of the rules, subject to the following terms and conditions. Kindly have the next page here. The lessee shall pay the highest rate of royalty prescribed for the iron ore containing 65% Fe. So this is the most important and essential condition, my lord, that we have to pay the highest rate of royalty. So it came at a particular condition, which, as I indicated, we have paid, and that totals 1560 crores till 2014.
Yes, yes.
Second,
You have already mentioned in your written notes.
yes, my lord, I'm just correlating the document for my lord's kind convenience. But the advantage of the list of dates and the submission is it gives the context. So when I show the document, my lord, I can place it in that context. And second is that it had to be weighed in the weighbridge of the lessee in the presence of the government checking staff.
Constructive dispatch.
So, my lord, these are the two conditions which they said on 27/3/2004. So the argument, my lord, from that day, constructive dispatch had already taken place, title had already passed. It was only a question of keeping them, which was transported later in point in time. Yes, and my lord, on this, all statutory dues, levies, taxes, everything has been paid. So nothing remained. Royalty, taxes, regulatory duties, all of it stood paid. Now, my lord, comes the most important document, 5/4/2004, which my lords will see at page 67.
Yes.
Lord, 67 is the typed copy. And my lord, this is what we call that composite stroke special arrangement in the note which I had read for my lord's consideration. This is this document. Lord, kindly note the date 5/4/2004 on top.
Yes.
Yes. Lord, it is from the office of the Deputy DPM Joda and it addressed, my lord, to the petitioner. I am hereby giving approval of the director DD mine for supply of iron ore on X mine basis within the leasehold area to Jindal in accordance with the provisions of the regulation rules subject to the following condition. And your lordships have already seen, my lord, highest rate of royalty. Second, it will be supplied at the weighbridge in the presence of the government checking staff. And then, my lord, the buyer will strictly follow provisions of the rules, etc., which are framed. And fourth, the officers will verify the accounts, including stock of material, and take an extract of such accounts on regular intervals. So, my lord, this is why I indicated the figure of the highest paid royalty, which is over 1500 crores, which my lords have noted. And the rate was 24.5 per metric ton of the entire.
Only for first year. Only for first year. Only for first year.
Which one?
24 is only for first year.
Yes, my lord, this was the rate at that time for the first year. But the aggregate figure, as I've indicated, over the period till 2014 is over 1500 crores.
IBM started to publish ASPs.
Right.
So it became an ad valorem percentage of ASPs.
And my lord, after 2010, I'm instructed, the IBM published the average selling price. So then it became an ad valorem rate. So this is nothing hinges on it, but this is only for completeness. Now, my lord, if my lords could kindly have the next document, which is to be found at page 70.
So page 69.
Sorry, page 69.
First one.
69, my lord. Serial number 6 of the list of dates. 10th May 2004. Now, my lord, kindly just have one clause, which is the additional one, which is number 1. Transport schedule should be limited to working of the
working.
Some word, my lord, I'm sorry, it's much of the weighbridge. This is just to say additional condition was imposed. And now kindly have, my lord, 70, the next page.
Most important.
Working hours of the meeting.
And please see, my lord, this is the statutory form D applied for by the buyer.
Yes.
And this license is granted, my lord. And serial number 11 shows for the period January 14 to January 16.
Document आपने miss किया इसकी first 3 lines authentic translation of ROM पहले 3 lines पहले.
So, my lord, the license is given to JSPL And serial number 7 says what is covered under that is iron ore, and 11 is the period, my lord, from January 14 to January 16.
Yes.
Therefore, my lord, the petitioner was allowed to supply this to Jindal, my lord, on the X mine basis. So the iron ore ROM is what they were giving to the buyer, all of which is approved under the 5/4/2004 document, which I showed the court. Yes, and my lord, that within the leasehold area, as I have indicated, is the special arrangement and the highest rate of royalty, which my lords have seen in the 5/4 communication and the communication prior to that. So this is the arrangement, my lord, on which the entire case hinges. And as I indicated to my lords, this is not noted in the impugned communication at all. That is why it becomes central. The answer to this, not that there was any piece missing in the puzzle, but if I may.
Yes, Mr. Jain.
Yes, the riddle and the puzzle created by them, like they say, you create a ghost and slay the ghost, is in this arrangement duly approved, my lord, and noted. Then, my lord, kindly come back to the list of dates. Just your lordship may only note that page 114 is the document of 31st March 2014, my lord, asking us to stop mining. So that's just a date, nothing hinges on it. I have said in the note also that it is the date on which we were asked to stop. And my lord, on that date, this is the crucial thing to note, my lord, it is on that day that is 135.04 lakh metric tons of ore, my lord, which was only stored within the leasehold area of the petitioner, which was fully royalty paid, all taxes, duties, everything had been paid on that basis. Now, my lord, kindly have page 115. That is the admission which I indicated to my lords, 12th March 2015.
Yes.
It should be annexure 10, and that would be, my lord, serial number 14, list of dates.
Serial number 2.
Not serial 14 of the list of dates.
Annexure.
Annexure 10.
Annexure 10, serial number?
Not in the list of dates which I had handed over to the court.
Oh, yes.
Serial number 14.
Yes.
Yes. Now, Lord, this is very important. It's a communication of the respondent itself. Please see. 2. Deputy Director Mines, my lord, she is on top.
Yes.
Yes. With reference to the subject and your letter, it is to report that stocks of iron ore are lying at the petitioner's mine and Jindal, the buyer, have been measured from 11th February to 7th March 2015 in the presence of representative of the petitioner and the buyer. 1. The petitioner stocks lying in the stockyard have been measured. Now, my lord, kindly have 2. The buyer Jindal had 3 stocks of fine situated near the crusher within the leasehold area of the petitioner. Both fines and ROMs above stocks have been measured. So, as per 5/4, all of this was verified. It has been measured. Now, my lord, kindly have the judgment of your lordship's court of 8 April.
Page number 6.
What is it?
That's the entire measurement.
Yes. Not 116, which is with 115, is the actual stock measurement, which is referred to in clause 2 of the document at 115. It just gives the stock measurement of all the ROM or etc. fines, but only to say all of it is measured, known, no dispute at all. Now, my lord, kindly have the judgment which I indicated.
Yes.
Starts at 117. And if my lords could kindly have page 123. Para 35.
120.
Not 123, para 35.
11.
This is not extra 11, the very next annexure.
Yes, that you had shown earlier also.
Yes, not I had just extracted it in the list of dates. Just showing my lords, this para, only one para I'll place, not because this is very important.
No, this is different. Yes, which paragraph?
Yes, not para 35.
It's the main petition.
May I, Milord, with my lord's permission?
Yes.
In the facts of the present case, admittedly, the seller, that is not the same petitioner before my lord, has effected delivery of the iron ore to the petitioner, and the petitioners have processed the ore into sized iron ore and fine, and is seeking permission for transportation. It is clear that under Section 33 of the Sale of Goods Act, once the petitioner delivers the goods to the purchaser, that is JSPL, and the petitioner in turn has paid the seller the value thereof, including royalty and taxes, the contract is duly performed, and the right, title, and interest in such property vested with the purchaser, that is JSPL. Consequently, the attempt made by the state prevents such transportation after the right, title, and interest in the property has been transferred to the purchaser, JSPL, and cannot be justified in law, since the petitioner in their capacity as buyer is no longer governed either by the MMDR Act nor the 1952 Act itself. Now, Lord, please see.
So what happened when this order was challenged?
Yes, Lord, this order was challenged in the Supreme Court. And when I show the Supreme Court order of 31/2022, which is coming next, Lord, I had indicated the Supreme Court notes that no dispute remains between the parties. And I believe, my lord, this challenge no longer remains in the Supreme Court. So this has also attained finality. Now, my lord, only note one more para 38. May I?
Paragraph 38 of what?
My lord, same judgment.
Yes.
Your lordship's judgment of 8th April 2016, para 38. But first, they may not quash all the communication. Now, kindly see the direction given by my lord's court. The last 5 lines of para 38. We further direct that the respondent shall grant permission to the petitioners to transport the entire ore, lumps and fines stacked from the dispatch point located within the leasehold area of the petitioner to its plant at Odisha and or so and so, where it can be transported by the petitioner. So, my lord, these are the para 35 and 38 are directly relevant for the purposes of the present case. And again, your lordship will note, none of this was considered in the impugned communication, which is why the violation of the principles of natural justice are more egregious, because you don't note your own specific arrangement, judgment of this court, and directions of the Supreme Court. In the teeth of that, without a show cause, without an opportunity, without a hearing, Lord, this illegal demand has been
after the
raised.
transportation has happened. After the transportation.
Yes, and my lord, much after, as I say, the horse had already flown, transportation happened, is a pure afterthought, and as I indicated, Lord, nothing but a second time royalty in a double dip, which would be both illegal and nothing but a form of unjust enrichment. Now, my lord, kindly have the order of the Supreme Court on 15 January 2020, serial number 19 of my list of dates. This is Annexure 12, starts at page 125. And my lords may kindly have 127. Para 5.
Yes.
The petitioner is granted 1 month's time to deposit the dues. In addition, they will file an undertaking to comply with all rules, regulations, and mandatory provision. 933 crores. So, my lord, 933 crores were paid by us pursuant to this order.
Everything of the petitioner is paid now.
So, my lord, everything paid, if I may use the word loosely, story over. but anguish does not end. Now please have 30th of January 2020, the Supreme Court order which shows there is no dispute between parties.
High Court order is B.
This is at page 145, para 20. Lord, this starts at page 135. Would you, my Lord, have 135? Lord, kindly see, it says Civil Appeal 850 of 2020, arising out of SLP 23644 of 2016.
Yes.
Lord, this is the SLP against the 8th April 2016 order, which I just indicated. And my Lord, this records the fact that no dispute survives between the parties, which I am going to presently show to the court, which my Lords will get at page 145.
144.
Yes.
But actually, I should start at the bottom of 143. I'm sorry for complete.
Bottom of?
Well, 143.
Yes.
May I?
Yes, please.
As noticed above, the appellant state had raised several disputes and questions of law, but at the time of hearing, both sides confined themselves to the solitary issue regarding the entitlement of the petitioner to lift and transport iron ore from the petitioner's leasehold area to its plants in Odisha and Chhattisgarh. Thus, no occasion arises for venturing into numerous legal disputes raised in the main appeal. Counsel for the appellants have expressed no objection to disposing of this petition in the light of subsequent developments which have taken place post filing of the appeal, subject to the petitioner filing the aforesaid undertaking. In the light of the fact that the parties have restricted their contentions and our consequent analysis to the framework of this, we dispose of the IA as well as the civil appeal with the following directions. Just prior to that, my Lords will note when he says subsequent development, etc., that is noted in para 17 at page 143. If my Lord could just come to the adjoining page.
Yes.
It was urged on behalf of JSPL, my Lord, that is the buyer, that in the light of the directions by the court and the consequent undertaking given by the present petitioner, my Lord, before this court, to comply with the same, kindly note, my Lord, no dispute survived between the buyer and the lessor. The counsel for the state did not controvert this fact situation. So, my Lord, that issue which was adjudicated by my Lords on 8 April 2016 attained finality since the undertaking had been given, and the court notes that the counsel for the state says that there is no dispute between the parties. That's how this SLP stroke civil appeal came to be disposed of. Now, in this background, please have page 144.
Yes.
Now, kindly see the conclusion. Please have number 1. Petitioner's prayer for modifications was granted. Now, my Lord, kindly last 4 lines. Petitioner must pay its dues and give the requisite undertaking, post which it will be at liberty to resume its mining operation in terms of our order of 15/1/2020, my Lord, which I just showed, my Lord, at page 127. Now, please turn to 145. And this is, my Lord, crucial for the present case, the direction. Once SMPL, that is not the petitioner before my Lords, complies with our direction, which my Lord has been complied with, JSPL can lift the already mined, processed and royalty paid iron ore lying at the dispatch point within the petitioner's premises and transport these to its plant across the country. So, my lord, this clinches the issue at the level of the apex court.
No, but what is the purpose of this order, Mr. Jan? Once SMPL complies with the direction number 1,
yes,
JSPL can lift the already mined,
yes,
processed and royalty paid iron ore lying at the dispatch point,
yes,
with SMPL's premises,
yes,
and transport these stocks to its plants across the country. This is one.
yes, my lord. So
the proceeds thereof must be deposited with the trust and retention account under the custody of the State Bank of India.
yes. So, my lord,
That if
so, my lord, the most important point here, two things follow. Your lordship have noted.
Please,
that-
Mr. Jan, please wait for.
What is that proceed? The proceed which who has to pay?
My lord, at that time, the proceeds from the state, kindly see, JSPL can lift, mine, process, and royalty paid iron ore at the dispatch point within the premises and transport. So, as far as the buyer is concerned, my lord, they say you can lift and transport it to its various sites. Now,
Thereafter, there is some
yes,
observation.
but at that time, these stocks had been hypothecated. So, the court passed an order that the proceeds must be deposited.
first to the bank.
Yes, first with the account of SBI so that the dues of the lenders can be satisfied.
So please come to Roman paragraph 1 again.
Yes, madam.
It says SMPL's prayer for modification of our order dated 5/1/2020,
yes,
wherein 1 month time was granted for payment of dues.
Yes.
Assessed by CEC is accepted. Then it says SMPL must pay its dues and give the requisite undertaking by 29/2/2020.
Yes.
Which alone it shall be at liberty to resume its mining operation.
Please, my lord.
So this amount was required to be deposited.
Yes.
In the trust and retention account.
Just one.
Correct.
We can't hear you. We can't hear you.
No, here.
My lord, just kindly have page 142 for a minute. Of this.
No. That stock which JSPL wanted to lift or whatever, is it the stock which was alleged to be a result of illegal mining?
Yes.
For which the Supreme Court had directed you to pay this amount?
Yes, my lord, your lordship will get that at 142.
Following which they will be allowed to lift.
That's correct.
That extension of order was given.
Yes, correct.
Deposit the amount.
Correct. Correct. That's noted, my lord, at para 14 and 15 at 141 and 142. May I read, my lord?
Yes.
During the pendency of, I'm reading para 14 at page 141. During the pendency of this appeal, the petitioner, that is my lord SFPL, I call it the petitioner for my lord's convenience, filed an application for intervention and referred to in the order of 15/1/2021, which I have placed, whereby this court, noticing irregularities by several companies, directed the petitioner to deposit dues assessed by the CC in its report on so-and-so and file an undertaking to comply with all rules, regulations, provisions, etc., post which it could resume its operation. SMPL has filed another application, number so-and-so, undertaking to comply with this court's direction of 15 January with a prayer to extend the time till the end of February for doing the needful. Additionally, ICICI and State Bank of India have filed intervention applications claiming that as part of a consortium, they had granted 8,400 crores to JSPL as working capital. Part of these loan amounts had been used by JSPL to buy the iron ore from the petitioner, and these stocks were in turn hypothecated with the consortium.
So in that background.
It was in this background, my lord, that this was passed.
Yes.
So I go back, my lord, to 145, which I have just placed for my lord's consideration. That was the operative direction given. Now, my lord, kindly have immediately after this, upon this happening, at serial number 22.
Yes.
Your lordship will get at page 146 now. Mining operations, therefore, my lord, could start from 1/2/2022, and this is the transit pass which was given.
Yes.
So, sequence as my lord has seen. Sorry, may I just start from 21, just for completeness, in the context of the Supreme Court order? Serial number 21.
Yes, Mr. Jan.
Lord, serial number 21 of the list of dates. So, Supreme Court order comes.
Yes.
Then the Deputy Director of Mines issues a letter of 31st January 20 allowing us to apply for removal of the iron ore, which, my lord, is lying at the dispatch point within the premises of the petitioner, to be lifted and transported by JSP to their plants across the country. Then mining operations resume on 1/2/2020 after a gap of 6 years, as I indicated, from 2014. Now, please see most importantly, 2/2/20, petitioner was granted permission to allow transportation of the iron ore, which is owned, as I indicated, by JSP. And in this permit, the opposite party has admitted that the iron ore belongs to JSP and is royalty paid. That, my lords, will get at page 146. It's at statutory form L, which I indicated. So, one is the judgment of your lordship's court, SLP disposed of. Now, kindly see their own document, my lord, which notices this. My lord, it's at 146, annexure 14.
Yes.
Lord, your lordship will see form L on the top.
Yes.
And it says transit permit for lessee. Yes, sir, with reference to the application of 2nd February 2020, you are allowed to, kindly now note these words, to remove the iron ore from the stack from your mine to the destination, that is Jindal, and this is the validity of the permission. And now please have in the column called particulars, the last item under the head remarks.
Yes.
Royalty paid and all taxes paid iron ore as per the judgment of the Supreme Court dated 30th of January 2020. And the DDM's communication of 30th of January 2020, which, my lord, I just indicated.
Page 49 of rejoinder.
Yes. It's at page 49 of the rejoinder. Just if my lords could just quickly have a look, because this clinches the issue, my lord. After this, the matter should have rested. Please have page 49 of the rejoinder.
Yes.
Annexure 20.
This will be, my lord, annexure 20 at page 49 of the rejoinder.
Just a minute. Next.
Lord, annexure 20.
Just yes, it's there. Yes.
Yes. Now, my lord, kindly see, this is 31st January 2020. Kindly note, my lord, addressed to us, heading resumption of mining operations. Sorry, it's a little faint, but please take it from me, my lord. It says resumption of mining operation.
Yes.
With reference to this and the subject cited above, I am to say that as per the judgment of the Supreme Court and the instruction of the Director of Mines, dated 31/1/20, you are allowed to resume mining operation.
No, just a minute. This is annexure 20.
No, my lord. Yes, annexure 20 at page 49.
At page 49. Yes.
Yes, my lord, of the rejoinder.
Yes.
May I just read that paragraph?
No, please read it again.
Yes, my lord, I'm on para 1. With reference to the letter and the cited subject, I am to say that as per the judgment of the Supreme Court dated 15 January 2020 and the instruction of the Director of Mines communicated on 31st January 2020. Now, my lord, kindly note these words. You are hereby allowed to resume mining operations. So, as I showed, my lord, judgment of Supreme Court implemented, amount paid, undertaking given, he says resume. Now, please note the second paragraph. That is absolutely relevant to this present petition. Besides, as per the order of the Supreme Court dated 30th of January 2020, you are allowed to apply for removal of the iron ore. And kindly note, these are the crucial words: already mined, processed, and royalty paid, lying at the dispatch point within your premises to be lifted and transported by JSPS to their plant across the country. So it fits in, my lord, pursuant to my lord's judgment of 8/4/16, Supreme Court judgment. All of it is royalty paid, and they say you can lift it. Now, my lord, kindly come back to the sequence. So this, my lord, takes us to that 146 which I showed, which again notes royalty paid, all taxes paid, iron ore, as per the judgment of the Supreme Court. Now, in this slide, my lord, kindly see the impugned communication at page 52. Yes, my lord, 52 is the impugned annexure 1, it should be in the writ petition.
Yes.
Lord, just first note the most important thing, my lord. If my lords could just make a note here, I'll be extremely grateful. My lord, 5/4/2004, their own document, not referred. If my lords could just kindly note this here, it will become very easy, my lord. May I, my lord?
Yes.
Yes. So, my lord, I'll just say it for my lord's kind convenience. 5/4/2004, not referred. 12th March 2015 letter, not mentioned. Supreme Court judgment, 30th January 2020, not mentioned. 8/4/2016 judgment disposed of by Supreme Court, not mentioned. Resumption order, which I showed, not mentioned. My lord, I'm putting it very mildly, not mentioned. Point I'm saying is it is contrary to all of that in the face of it. And all of this, my lord, is in respect of, now my lords have seen in every document, royalty paid or entire amount has been received by them at the highest rate because of that special arrangement. Transaction between us and the buyer was concluded as far back as 2014, settled by a judgment of this court. Ownership then is with the buyer. Now, my lord, kindly see, in the absence of that, he says, please pay differential royalty. Now, with greatest of respect, when it is fully royalty paid, transaction is over. That's the end of the story. Now you can't say because you're moving it in 2020-21, you now pay it at the IBM rates, because the ownership of this, the title has already passed and vested with JSP. It's over. Contract is concluded. Delivery is over. Sale completed. It is merely stored in the lease area in terms of 5/4. So the nature and character is completely changed. So now you are saying pay a second time royalty, unjust enrichment, double.
That's the question, Mr. Jain, whether the delivery was over or not.
Yes, over, my lord.
That is the precise question.
Absolutely.
The 1:1 says that.
Constructive delivery. It's clear. And my lord's judgment has clinched that issue, which is why I would have pains to read para 35.
That we remember. We will consider, Mr. Jain.
Loyalty online.
We will consider, Mr. Jain.
You will not be there of GSP.
Yes, and my lord, sorry, when I showed my lords all the admissions in my list of dates, I had also showed the admission in the impugned order. Now, just kindly just note that also, my lord. In the first para, penultimate line, It again says that 135.04 on account of JSPL. Please see, my lord. Royalty paid on account of JSPL.
Yes.
So he notices royalty paid and he says on account of JSPL.
Yes.
So, my lord, with greatest of respect, the first point which I started with, the natural justice point, is crucial given the history between the parties starting from 5/4/2004. Judgment of your lordship's court, Supreme Court didn't interfere, says dispute sober. Supreme Court judgment, no dispute, this is royalty paid owed. So, my lord, all of it is constructively removed. It was only a question on that day of physical transportation. That's it. All of it had already happened. But once the title passes, my lord, it's gone. And when they try to link transportation with mining, your lordship's court says, no, that's wrong. With that, my lord, they have no basis or case at all. This would be a clear case of unjust enrichment now. And, my lord, Form L is only issued where it's royalty paid owed. So the statutory form also based on Rule 10, which I indicated, my lord, in my list of dates my lords have seen, that also takes care of this. And the separate codes for this material. But, my lord, in this light, now have my last box.
Yes.
Form, my lord, page 146, I had shown Form L also, my lord.
Yes, sir.
Now, my lord, the next limb is to be found at page 11 of my note. That is the DMF and NM. So there are three ingredients, my lord. First one I have already addressed and mentioned to the court that you cannot, my lord, create an illusory demand of any differential royalty. All of it is, my lord, already royalty paid 936 crores, received overall over 1500 crores till 2014. Now the next two elements of DMF and NM. That's box 0.3 at page 11. The provisions regarding DMF and NM were only introduced in the MMDR Act from 2015 onwards. Hence, there is no applicability of the same on the lifting of the processed iron ore by JSP from the mining lease area of the petitioner. Admittedly, the demand under the head of DMF and NM cannot be retrospective in nature and cannot be levied upon by the petitioner. I'll just show a judgment. The petitioner have complied with all regulatory and legal requirements, including payment of the highest prescribed royalty rates and conditions set forth in the letter of the legal, that is the 5/4/2004 letter, which is the most crucial letter because of the specific arrangement between the parties. Petitioner number 1 had approval dated 5/4/2004 for selling ROM to JSP. The sale of iron ore has already been made in the period 4 to 14 as per the express permissions which have been given. The legality of the sale has been affirmed by this court in its order of 8/4. The sold iron ore lying in the mining leasehold area could not be lifted earlier as the mining operation of the petitioner was suspended due to no fault of JSP. The subsequent lifting has already been directed. My lord, I have shown the judgment of the
Yes, please wait, Mr. Jan. Yes.
Lord, I had just a suggestion for my court's consideration. I have pretty much done the facts. I am there before my lords physically on the 5th. May I do the judgments on that day, my lord, when I'm physically in court, just and do my conclusion on that day?
Then you can do it on 9th. It may be difficult because
Very well, ma'am. I'll do it on the 9th.
on 9th. Yes.
Case would be over within next 10 minutes. If my learned friend.
Yes, yes.
It's very simply. It can
We
be
will
answered in 10.
hear you in reply, Mr. Jan, on the next day. Let us hear. Mr.
No, Milord, I have not concluded with greatest of respect.
No, but let us have the view of the advocate.
5 minutes.
If you want some time again, so let it go, but the case is for hardly 10 minutes, Let him conclude. I will reply.
Milord, let me.
On that day, what do you want to say?
Or fifth, all right, if my blunt friend.
With greatest of
All right,
respect.
9 then.
Yes, 9.
9.
Yes.
Grateful, Milord.
9th, you don't have any problems, Acharya?
I will be there. It's a huge demand of around 700 crores.
That is immaterial.
It's state interest.
Short questioning is already paid for that, but
No,
since
it
he had
has
not,
not been paid. I'll answer.
since he had not removed it,
No, it is not. The answer is not that easy. I'll explain. It's
what
not.
do you say 5 minutes?
No, but Mr. Gopal Jain is not permitting the land advocate general to argue.
Milord, may
All right.
Milord, may I rephrase it? I am at the crease still not out. So only at the fall of my wicket will get a turn. I cannot prevent him.
Let us.
And your lordship,
My duty is to protect.
Milord, your lordship will decide whether I am out.
Balance between.
Let us.
Your lordship will decide whether I am out or not out. So I'm in my lord's safe hands.
All right.
Milord, on 9th.
9.
I'm so grateful. Extremely grateful.
Item number 13.
Cost paid? Has the cost been paid?
Yes.
Paid.
Yes. Who is for the state?
State is the appellant. Item 13, state is the appellant. Who's going to address?
On appeal from the appellant.
33.
Yes.
Item number 15.
All right, it will come on 9. As requested. Yes.
This matter relates to the regularization of the scope and attendance. So far, the sanction is concerned, but the particular school sanction has got only one peer. There is no any sanction or scope on it. But district welfare officer appointed the respondent against that post, and he has continued for a longer period, and he has a lot of linkages given direction for the regularization.
Your Lordship that day posed the question whether without advertisement, how you are the appointed respondent. Next sure, one is page 41 is the sanction letter.
So you were appointed on 31/12/2007. On 31/12/2007. After Uma Devi. And despite Uma Devi.
To that respect, I may permitted submit in two. First of all, the order passed by the Lawrence judge. I was the counsel in that court. The sole ground of rejecting my prayer was that you are appointed on daily wages basis.
Mr. Counsel, we will not go into that aspect. We will go into the sole aspect whether there was any process of selection adopted or not. If not, then sorry, because that is in violation of the Supreme Court's order. Where is the question of application of Uma Devi?
As per my information, there was an advertisement. There are 60 to 70 candidates were there. The process of selection was conducted by the collector himself with 5 senior most officers of the district. Okay, the process is not conducted by a collector. It is conducted by a village. In my engagement order, the nomenclature has been wrongly added as cook. But actually, I have been selected for the post of PO. There are 60 to 70% persons are there. And in that regard, one decision of this Honorable Court, the division bench order, which has been confirmed by the Honorable Apex.
Confirmed means approved.
This has been it was a case from the tribunal.
No, with had
for the
whether the judgment of this court has been approved. Whether the judgment of this court has been approved by Supreme Court. Let us see where is the order. Especially petition is dismissed. Similarly, in limine, it does not amount to approval.
No,
or affirmation.
It was on SLP. The order of the SLP was that no ground for interference at the exercise jurisdiction 136 and the specially person is accordingly.
Yes.
That was the order of the Honorable Apex Court. And the finding of this Honorable Court in the division was that the last part, paragraph 4, the last part. However, while pertaining with the order, we may note that whatever may be the mode of engagement or appointment, there was concurrence of the finance department and the employee in question were engaged in different departments of the government, rendered their service uninterruptedly. Beside that, mode of engagement adopted and selection process followed was consciously adopted by the relevant.
This doesn't apply in your case. This doesn't apply. There is no report there was any selection process.
My submission that I have come through a regular process of selection.
Regular, where is that? Where? How do you say that?
That is the file they have lost.
File they have lost.
They have intimated it in my RPI.
Very difficult.
You should be having an advertisement which is.
And another decision. The Umadevi case also has been done, referred in this case. Shivnarayan Nagar.
So he was, in that case, the person was appointed in 1993, before Uma Devi. That is the difference. That is the difference, that despite Uma Devi, despite MLKST, despite several decisions of the court, Supreme Court, the appointments were being made after in 2007, 2008.
My information is
Then there was a regular post, there was advertisement, and there is a regular process. In this judgment, there is a specific noting that the spirit of Uma Devi has been ignored and conveniently overlooked by various state governments. We regretfully make the observation that Uma Devi has not been implemented in two states and has been.
Mr. Uma Devi will not apply in your case because in that case the person was appointed in 1993, much before Uma Devi came. And your appointment was after Uma Devi.
After Uma.
So Uma Devi was for the persons who were already working, and for them the court had directed to formulate some scheme for their regularization. It is not that Uma Devi said that thereafter all the appointments can be made on contractual or daily wage basis. 10 years thereafter they shall be regularized. It is not Uma Devi.
The only point is that they have lost the fight. That I would not say that there was a regular advertisement, there was a regular process.
So therefore, that these aspects have not been considered by the learned single judge.
No.
The learned single judge did not have the occasion. Did you plead? Had you asserted in the writ petition that your selection was after due process?
Yes.
You had asserted. Let us see.
Single judge has allowed my case.
All right. Third learned counsel appearing on behalf of the learned AGA representing the applicants, and learned counsel appearing on behalf of the respondent. This matter for judgment on. Who reads that? That's all not.
Item number 16.
So cost has been paid. No, sorry, this is the second one. 15 already.
16 is on. Item 16.
Here, last time I have taken time to file petitions to call for certain records. It is two IAs I have filed. IA 14900 and 14901. So far, IA 14901 is concerned. There I have prayed for minutes of this accounts committee to be, public accounts committee to be furnished by the opposite department. I have made a reference of
how can these things be reopened in a PIL after so many years?
But I have given amendment in the writ petition itself by saying that the public accounts committee was in the session of the matter and the member board of revenue was summoned there, and he has agreed that this order should be challenged, and thereafter there is no action taken. That is how.
Where is that?
Commissioner. At page 14. Commissioner. In the process of inquiry and probing into the matter, the petitioner time and again, B, time and again not only had been to the office of the Tahsildar but also to the office of the collector Bolani. In course of discussion about the matter, the petitioner learned that not only that matter was within the attention of all the revenue officers but also was subject in the assembly. The petitioner further came to know that before the Public Accounts Committee of the Assembly, such issue cropped up, and the Commissioner Land Reforms, who appeared before the committee, admitted that the orders in the shielding case are illegal.
Which paragraph you are reading?
Paragraph B in page 14 of my report. Page 14, 1-4.
Had been to the offices of it. This is quite vague. Such statements are quite vague. When did you visit? Give the details. You give the details. When did you visit? So you are approaching this court after so long, and that too in PIL. You give the details. Let us see your bona fide also.
I have said that on several.
No, that's quite vague. Those statements cannot be accepted.
Let's.
We are not rejecting your case. You explain that.
What I'm trying to submit. If it is a fact that the Public Accounts Committee was looking over the matter.
First, why should we put them to notice?
Let them take it.
Why? You should be clear on your statement. You file additional affidavit. Senior counsel appearing on behalf of the petitioner states that he shall be filing a detailed affidavit explaining the an additional affidavit giving the details when the petitioner had approached the authorities as stated in 6B of the writ application. Stop. This order is being this order. The court will thereafter consider the bona fide of the petitioner in approaching this court by filing the present writ application in the nature of public interest litigation. Yes, file.
The other mistake is to call for the records.
No. First of all, you justify your bona fide. 4 weeks.
Item 17.
Yes.
Item 17, my lord, the second matter I have to file a rejoinder. My lord, the second matter I have to file a rejoinder.
How much?
1 week, my lord.
1 week time is out for the petitioner. In WPC number?
18543 of 2024.
To file a rejoinder to the counter affidavit. In this case, 1 week. Yes.
Item 18. Item number 18.
Appears 1 week. Yes.
Item 19.
Please, my lord. I was the lessee of a minor mineral source millers in 2016. After the lease was granted, the NGT stopped, closed that. That is why Annexure 1, I order dated 1st February 2016. That interim order stood vacated by Annexure 2. It is on 22nd 11/2007. And 2 or 3 months thereafter, the state government resumed operations. So I came up in a petition before this court, my lords, for extension of the lease for that period. That was allowed by Annexure 3 at page 18. And if the lordship will see at paragraph 4, this court directed the Tahsildar Soro for extending the tenure of the lease. My lords, despite the direction, my lords, the Tahsildar didn't act. And another writ petition was filed that was disposed of at Annexure 4, saying that the representation before the Tahsildar should be considered. Now, what had happened is, by then, my lords, the Tahsildar was no longer the competent authority, because by a notification dated 21/11/2022, the administrative control had been transferred from the Revenue and DM Department to the Steel and Mines. So therefore, I filed a representation at page 24 before the DDM millers, Bhadrat millers. That is still pending, he has not considered.
File your affidavit. File your affidavit. Issue notice, transfer notice. So, 4 weeks time is allowed. File counter affidavit, this is matter on 4 weeks. Stops in between while it will be open for the opposite parties to consider the petitioner's representation at
Annexure 5/1.
Annexure 5/1. And 5/1. Trustee.
When the order was passed in your favor, that time the amended rules had not come, 2021. So after 1 year it came. So 1 year, what happened?
Lords, he didn't act and petitioner was not aware of this. So he moved this court again and your lordship permitted.
Petitioner was not aware of that order.
No, he was not aware of the transfer, my lords. So in the secondary,
1 year. Okay.
in the secondary also that was not.
Item number 20.
May I please,
Yes.
Your Lordship, I'm challenging the order dated 16/12/2021 passed by the collector, Your Lordship, wherein a decision was taken redundant to the previous decision that was taken in the year 2009, Your Lordship.
Yes, last time it was adjourned, no?
Yes, Your Lordship.
Your instance.
Yes, Your Lordship.
So
Your
they were
Lordship,
not.
as per the instruction that I have, Your Lordship, is that the order was kept in abeyance, Your Lordship. It was not implemented. And since it was not implemented, the petitioner did not.
No, madam. Dismissed.
Only after the change of the government, Your Lordship, only after the new collector came into power, Your Lordship, the same
Change
has
of
been
the government. Change of
No.
the government and posting of new collector.
No, Your Lordship, only the present officer in
Sorry.
charge, Your Lordship, the collector, has
Sorry.
taken this decision. Your Lordship, I'm challenging the decision of the present collector, Your Lordship. The implementation of the order.
What is your prayer?
Implementation of the order was passed. We challenging that. Because now it is being
Exactly.
dismissed on the ground of delay and that's just. No. Yes.
Item 21.
21, I was supposed to file a counter. I have prepared it within a day or two. I have filed.
All right. 1 week time is allowed for the state to file counter affidavit. It will matter 1 week. Yes.
Item 22.
22, I have verified the procedure. Where the petition will secure 44% from one or will secure a minimum of 2%. And your lordship that as per their instruction, I have deducted that amount can be refunded. And
We'll refund it.
Is an admitted position that the petitioner has a petitioner could not obtain a minimum qualifying marks of 40%, 45% for admission to BSc nursing course in Kalinga Institute of Technology. So stop. Despite that, he had deposited a sum of rupees 75,000 for his admission. For her admission. So with the given that the admission is not being given to her, the petitioner filed the present writ application. So next one, senior counsel appearing on behalf of AIIT has submitted that the petitioner cannot be given admission because he has not scored the minimum qualifying marks of 45% in the subjects physics, chemistry, and biology taken together. So he submits that the amount deposited by the petitioner for her admission of 75,000 shall be refunded to her if she approaches the who will she approach?
The
registrar of it. So this application is accordingly disposed of with an observation that if the petitioner approaches the registrar for refund of the said amount, the same must be deposited, must be refunded without any delay.
Stipulated period.
Without any delay,
That will be done. Let us approach it.
yes, we will have to rise. We will have to rise. All the matters will be listed. All on next Monday, all the matters shall be listed.
I will tell you, urgent matter item 29.
What is that, urgent?
That is Sisu Bhavan matter.
Sisu Bhavan we will take up
When?
Next Monday.
next Monday.
Next month.